please, Your Lordship. Lordship, I need to list criminal petition 503 of 2024 for listing 3rd of September, Lordship. Right? 3rd of Wednesday, much of it.
May I please, Your Lordship? Your Lordship, I beg to mention item number 32 of today's daily list. Your Lordship, in this matter, TCR has been received, but notice has not been served upon respondent number 2, Your Lordship. Service awaits in respect of respondent number 2. 32, Your Lordship.
Service is still awaited.
Still awaited. As per office note dated 26/8/25, day before yesterday.
So what do you want?
Your Lordship,
you
matter may
awaited?
be-
Meant to be awaited for next date of listing?
Yes, Your Lordship.
That it is made by President. However, it reveals that service is still awaited for this morning. It is service be awaited. Is accordingly after 2 weeks.
Lordship, interim may be continued.
Interim be continued with the next.
Oblige, Your Lordship.
May I please, Your Lordship? Lordship, I like to mention criminal petition 205/25, 3rd September for listing.
First?
1st September.
No. What's the
Then,
number?
then 3rd September.
Okay.
Yeah, please, Your Lordship. I'd like to mention item 27, 28 to 29 of today's daily list may be kindly adjourned for the day, as the engaged counsel for the petitioner is out of station for treatment.
27, 28, and
29.
29. also.
29.
We are appearing in this case.
Yes.
It did not take our consent, my lord.
Why?
It's for
This
the,
type of this sort of complaining the
I was just here, that's why I could hear. Otherwise, I would have waited the entire day, my lord.
Yes. Yes. And generally I ask, in fact, what is the why have you taken the consent? And it sometimes too it happens in my court. I have come across 4 or 5 instances, wherein it was stated that yes, consent has been
Consent.
taken, and after some time the other side came, and then again this consent was never. So that should not be. You should take consent. Definitely, you have some problem.
Yes.
We don't have any issue. He also, I think,
yes,
will
yes, Your
cooperate.
Lordship.
But minimum, at least as this for this his convenience, at least you should inform. So in 3 matters, you also appearing.
I am
In
waiting
all
for the
3
respondent. It's an NIA case, my lord, and they have obtained a stay. The lordship will remember that case. Check had been lost. They had taken that plea for loss of the check. They find a question. They have obtained the stay. Let it come upon a fixed date, my lord. Any date convenient to your lordship, my lord.
Who is your senior counsel?
Triple S Rahman, sir.
Huh?
Triple S Rahman, sir.
SSS Rahman.
Yes.
The consent site. Taking that due to personal the and this counted for the petitioner. Which Mr. Sarfraz Nawaz, who is the please vote. Adjournment is allowed. It's the matter after 2 weeks, 3 weeks will do.
Any date, my
After
lord.
2
After
weeks.
2 weeks, any date.
After 3 weeks, 18th
Yes.
of September. 18th.
Much obliged, Your Lordship.
Your
Please.
interim is there, na?
Interim is
No.
there.
Interim is there.
Yes.
May
Interim
please, Your
continue
Lordship.
till next. All matters will be on 18th of September.
May it please, Your Lordship. With the consent of other side, I beg to mention item number 26 of today's list, Lordship. There is some personal
20,
health issue.
20.
Yes, Lordship.
26.
26, Lordship, may possible for the day only.
Here also
My lord, here I have one submission to make, my lord. If he has some inconvenience, my lord may adjourn it. But I pray, my lord, a date may be given, because this is a case where they have been convicted under NIA. They have preferred an appeal. In appeal, while admitting the appeal, the London Appellate Court has imposed the cost to that 20% compensation,
20%.
interim compensation is there.
That issue
Now,
is involved.
they have challenged that order, my lord. Now, because of the pendency of this revision petition, the appellate court is not proceeding with the appeal. But this was
yes.
pointed out on the last day, because there is no stay,
Mm.
but yet because of the pendency, appellate court is not proceeding. So when we pointed it out last day, so an order was passed that an endeavor would be made to dispose of the case today. And on the last occasion also, my learned friend had taken adjournment. So today also, if your lordship adjourns the case, I have no objection, but at least a date may be fixed, my lord.
Lordship, may fix
Because-
it.
Matter they are not proceeding with the appeal. My lord.
Because the appeal is still pending.
Appeal is still pending. Only the admission order, my lord, where 20% interim compensation has been directed to be paid. They are aggrieved with that order and they have challenged that order.
So you have some personal problem today,
Health issues, lordships, nothing. I could not prepare a brief last night.
health issues. The heart is very MK product, the petition. Not the heart is right. As Nawaz did on it. Written Mr. Bharat due to health issue. He could not prepare it for. Then accordingly. In that context, Mr. Nawaz also submitted that due to pendency of the present written petition, the appeal is pending before the learned court of where
Sessions Nagaon, my lord.
session judge Nogha is also accordingly submitted that the next date matter will be heard and considering submission made by council proposals. This day matter I will give a quick date here. Fifth of
Yes,
September will do.
Deeply observed.
Obliged.
Lordship, I beg to
May please your lordships, I'm senior to you. Okay. My lord, I have filed yesterday one anticipatory bail, my lord. Due to server down, we could not collect the number. May I move tomorrow, my lord?
No, if this bench is not taking the bail matters. You have to make a prayer before Justice
bench?
M.K. Kalita.
Obliged.
May I please your lordship? Lordship, I beg to mention a criminal petition for listing. Due to paucity of time, this matter could not be taken up on 4 occasions. The trial court date is fixed on 4th of September. May a date be given prior to that? Preferably Monday,
Second of
2nd September. Obliged, my lord.
May it please your lordship, I beg to mention listing of a criminal appeal in a motion column, your lordship. We filed it on 21/8/2025 since it has not been listed and the imprisonment is below 3 years and the judgment has been under section 325 and the judgment has been passed on 4/8/2025, your lordship. So your lordship may kindly take this matter on 1st of September or 2nd of September, your lordship.
still
1st of September, if your lordship as per the convene.
first of September.
So obliged, your lordship.
Hey, please, your lordship. Lordship, I beg to mention for listing of an IA regarding condemnation of delay in criminal appeal. Lordship, can it be on 3rd of September? Obliged.
I beg to mention item number 23, Lordship.
23.
Yes, Lordship. With the concern of others that matter will be adjourned for a day, Lordship.
You have taken the council. Listing matter according to. It will be listed after 2. As on it.
Now to praying for the criminal petition for listing for motion on 3rd September, 3rd September, and the case is already numbered.
Cannot let up. Let it be on 5th of September. The 3rd is almost full.
May I please? Lordship, I beg to mention for listing on criminal appeal, Lordship. 4th
Maybe on 5th of September.
4th of
5th of September.
April.
I am putting for listing of a criminal appeal for hearing on 9th of September.
9th is the hearing day,
9th, Tuesday.
Tuesday.
May I please your lordship? Lordship, I beg to mention for listing of criminal appeal for orders, lordship,
5th of September. at
5th of
least.
September. Deeply honored.
My lordship, praying for listing one criminal petition and one criminal for orders, lordship. Any next week? Any the next week if possible, lordship. Subject to
8th of September.
Eight, Lordship. Problem.
Your Lordship, 483 application, Lordship. In custody for the last 76 days, charge sheet was given in this matter, Lordship, and earlier rejected, Lordship. Rejection appears in page 25. Grounds it's that Lordship, the petitioner begs to say there is no evidence found in regard to her alleged pregnancy of the victim, Lordship. So section 89 appears to be absent in this case, Lordship. And it's section 69 of BNS appears in the FIR, Lordship, as deceitful means shall include in the inducement for false promise of
Just tell us,
employment or
what is the
promotion.
position of the case at present?
Lordship?
Is there any recording of statement,
Yes, Lord.
evidence? Evidence of, the evidence of victim has already been recorded.
Yes, Lord.
I don't think so.
After giving out the search sheet, the bail was rejected there, so we approached this honorable court before.
No, Mr. Kusap, what had happened? in
Already,
this,
Lordship.
one bail application was.
Seven-
Yes, rejected.
7, 8.
Yes,
76.
That was after filing of the charge sheet.
yes, but only the 183 statement is reflected in the order, my lord. Yes, ma'am.
But Lordship,
I
both
don't
At
think
that
that
time,
within
perhaps-
this period,
Perhaps at that time, it is not recorded, my lord. The position. Let the TCR be called for scan copy, then only.
we call for it
Lordship,
because there
tomorrow
is
is
no
the-
change of circumstances.
No,
any
ultimately,
change.
there is no change of circumstance. Other things will be same, man.
Plus, Lordship,
there any
tomorrow
change
is the
of
date for
circumstances?
consideration of
Is
search.
there
Lordship.
any change of circumstances present? I don't think so. After 7, 8.
7, 8.
25, there is no such changes of circumstances.
Only 10-15 days has gone,
Yes, only 10, 15 days.
no date.
Yes, Lordship.
Charge is already framed as per your information.
Lordship. Now the date is tomorrow is for consideration of search, Lordship. In the
Tomorrow is
Yes, Lordship. And Lordship, already 6 days has been.
days is
completed,
all right now.
Lordship.
Charge sheet
And
days
Lordship,
will
both
not-
measures, Lordship, if go to a measures, Lordship, and in the earlier scan copy in the report, there's no
See,
report
whatever
of
may be
any
the reason,
pregnancy,
because
Lordship.
earlier it was
At
rejected.
that time.
So there is no change of circumstances.
Yes, Lordship.
Only change of circumstances.
Lordship,
you
and
might
it may
wait
be
for
kept
this-
pending for few days, Lordship, because already 76 days has been completed, Lordship.
76 days in
Because
detention.
earlier
That
it
is
is
her
rejected in the lower court below, Lordship.
detention, my lord, 76 days, that is,
Days,
that
days.
is fine. That- Otherwise,
76 days. Okay.
This year we call for,
lost.
want to see the progress, if there is any progress.
Yes.
Especially because we, on the last occasion, there was
Yes.
an observation
Yes, Lord.
that the probability of hampering or tampering with,
No,
Yes,
that
Lord.
was the observation.
Yes.
So in that case, I don't.
so at least
think
victims,
the
if the victim statement
evidence
is
of the
recorded,
victim's
my
statement is recorded, then it's
then-
okay. Otherwise, there may be same situation. So
Right.
let this TCR be called for. Tomorrow is for
Hello, the-
consideration of
Yes, Lord.
child.
38, 98.
TCR be called for eligible. Ravi, after
Let it be, given at some long date perhaps, my because after charge,
Okay.
then there will be another,
Days, yes,
yes, and
after 23rd of September,
Yes, Lord.
then it may get some.
May I please your Lordship?
Yes.
483 application, Lordship. This is also second time application, Lordship. In this case, what happened, Lordship, rejected on 15/5/2025. And petitioner, charge sheeted case, search frame, Lordship, in this case, petitioner is inside the jail for about 2 years, 6 months, 12 days today. And during, after rejection of this, from this honorable court, Lordship, till today, Lordship, only one witness examined, Lordship. So in this case, my lord, what happened, co-accused also got bail from the court below, Lordship. sorry, from this honorable court, lordship. It is in page number 67. And the person is not named in the FIR only on the basis of the statement of the co-accused lordship, which was recorded under section 164 lordship. He was implicated that he was one of the conspirator lordship, like that lordship.
It was a murder. No?
Murder,
Murder.
my lord.
It is pending before lordship, additional session judge number 5, Metro lordship.
But till then, how many witnesses as per your information?
5,
Five witnesses.
only 5 lordship. At the time of hearing, 4, and now lordship 1.
Yes, to some.
My lordship, otherwise, my lord, there are materials against them, my lord. Since the,
Probably.
yes, my lord. Only thing, my lord,
We can see at least the progress.
yeah, progress. my lord.
Last witness was examined on when?
Lordship last month, 6th
Right.
6th of
6th of
July, lordship.
July.
July, lordship. Huh? 6th of July, I think.
Next day, yes.
Next date?
Next date, lordship, September, lordship.
Which
Lordship, I'm giving that. 223. Huh?
Question.
September, fixed for evidence, lordship.
6 September.
Lordship.
Okay. If 6 September is there,
That's-
we make the
But lordship, evidence is fixed for 17 October.
6th of, yes. the date.
6 for production.
for
Six-
production.
Only for production.
The sheet.
To not take my lord.
Hey, Mando.
Asking 1/6. 1/6 will
Lost once.
1/6. 16th of September. 1/6.
116. Can it be on, can it be on 13 or 15 like that, lordship?
13 or I mean, how they-
Fifth. Oh, sorry, no. Oh, September, no? Sorry.
Maybe one day prior.
Start at
15,
a bond.
maybe 15.
15. 15, lordship.
15 September.
Lordship.
This year we call for, along with the present status report of the case record. Yes, we will do the needful, list according to the.
But out of the record, I would like to thank lordship, one hearing matter lordship fixed in the division bench that has been finished. I'm highly obliged, lordship. What will be the outcome? It is another aspect, but I'm highly obliged, at least.
We are
Hearing
trying
part
to, we are trying also to deliver the judgment within a short period.
But lordship judgment, when it will come up, it is up to honorable court, lordship, but
Hearing
I'm
is
thankful.
completed.
Yes, lordship. It
Let's see.
took long time from in another bench also,
Hmm.
but lordships completed the matter. Lordship. That is why I'm thankful, lordship. All in it.
I plead the lordship. My lord, anticipatory bail application, your lordship. In this case, my lord, this is charge-sheeted matter, your lordship. All the co-accused have been granted bail by your lordship. And in this case, my lord, the present petitioner had no knowledge regarding the case. And during the course of investigation, my lord, the investigating agencies did not visit the house of the petitioner. However, his name is mentioned in the charge sheet as absconder. And on the basis of a statement of co-accused, his name is inserted in
Advocate, also it is the case of NDPS commercial.
my lord. I'm ready to face the trial, your lordship.
Yes.
Otherwise, all the co-accused
But,
are granted bail.
Since they're my lord, they are seen as absconder, my lord. And someone was also issued to him, my lord. thereafter BW bailable warrant issued. Then also they have not appeared, my lord.
My,
So, my lord, it cannot be, my lord,
my lord,
That
at
is
this
the
stage.
case of commercial.
Commercial quantity, my lord.
my lord, someone was issued, but in place of his father's name was wrongly mentioned. So he was confused. And
Because this is
your
an
lordship,
anticipatory bill, my lord.
your lordship may kindly peruse page 26, your lordship. Page 26. Order dated 21/1/25. Here, his father's name is corrected. Letter. May I read, your lordship?
Which I have seen on.
May I?
Now see, this is the case of NDPS that to commercial quantity.
But
And that apart, the other accused persons, they were most probably arrested in connection
Arrested,
with this and
they were
got
regular
detained.
bill, man. Not,
That is
not,
different.
that is completely different. As well.
Ah,
Here it is, the case is completely different, my lord. So, Union absconder, my lord, my
This
Honorable
case is not
Supreme Court
covered.
also, my lord, recently
More-
several times held that
let us
in
call
a
for the TCR along with the case diary
Lord.
to see the only
Lord.
conduct.
lordship,
Is there any house search or is there any?
lordship,
Because as per him, he was not available.
lordship.
Maybe also, I don't know. Let the TCR be
Commercial
called.
quantity will
TCR
cover, your lordship.
TCR along with, my lord, case diary.
Yes. Scan copy of the TCR along with case diary for rest it will be needed. That's when it can be listed.
Some Dhuguri, man.
Dhuguri PS.
Okay.
Dhuguri.
My lord, 15 or 17, like.
It will be on 69.
Yeah.
You have some problem.
No,
Yeah, you have taken.
59.
Hmm?
Your next date is when we fix next date is
my
fixed
lord,
on?
next date, I have no idea, my lord. On 5/8 it was fixed.
5, 8.
No, 6/8 it was fixed, but next date I do not know about.
Maybe
My lord, on 11 may be taken up, my lord.
11.
Okay.
Oh, 11.
11. House of Blessing. Please, your lordship. Anticipated bail application, my lord, it's the second time, my lord. Earlier in a group, petitioner filed a bail application because care of the petitioner was rejected along with others, my lord. Petitioner is an old person, my lord, and suffering from some health conditions, my lord. And you have to go to the for medical checkup in every month, my lord. And, being the father, my lord, his name was incorporated in the FIR because his 5 sons were incorporated in the FIR, my lord.
Yeah.
Petitioner's 5 sons were incorporated in the FIR as accused, my lord, and he is the father, so his name was also incorporated. In the last occasions, my lord, altogether 14 persons filed an anticipatory bail application. Your lordship has rejected that, my lord. Now the petitioner is for your lordship considering his case on his own merit because the order reflected that. Kindly have a look at page number 25, my lord. Page number 7. Paragraph 7. So here it is written, my lord, in the last row. The material in the case diary indicated all the petitioners tried to assault the victim, who are, maybe some persons were involved, my lord. An independent witness is necessary to be look into, my lord. And petitioner is 65 years old, my lord. So at this, my lord, CD may be called.
It is the case of charge sheet? No.
No. CD may be
Not
called for,
charge
my
sheet.
lord. Not charge sheet, my lord. CD may be called for, my lord.
City. Okay. City. Okay. It's still. It's Purva and it.
Oh, in 15.
Highly obliged.
1.
By please, lordship. Lordship, this present transfer petition is filed by
Srimati Meena Sil, who is the complainant in a complaint case 994 of 21, currently pending before the civil judge Dhubri.
Civil judge?
Dhubri, my lord. My lord, she has filed a case under Protection of Women from Domestic Violence Act against her husband Deepu Sil and her mother-in-law Srimati Sarojini Sil. My lord, the case is now at the stage of
Lost by, she herself lost the case.
Yes, ma'am.
Before?
Before the civil judge, my lord.
Civil judge,
Dhubri, my lord. This is a transfer
the
petition.
junior division.
Yes. But the case is now at the stage of cross-examination of PW.
Hmm.
And the next hearing is fixed on 4/9, coming 4th. My lord. My lord, the
Why you
petition-
did the transfer? Because you lost the complaint.
My lord, the petitioner was thrown out of her matrimonial home along with her minor daughter. And the petitioner took shelter at her parental home, my lord, and filed a police case at Tamarhat police station, my lord, against her husband.
Okay, after she was driven out from her matrimonial house, she lost the complaint or FIR, whatever.
Yes, ma'am.
My question is that she lost the complaint when she was in her
Matrimonial
house,
Matrimonial home, yes.
matrimonial,
Yes, ma'am.
and now she is here, her parental house.
Yes.
But whatever, she
My
lost the complaint.
my lord, now she is residing here in Guwahati. And my lord, it's difficult for her to go there and pursue the case, my lord. And her husband, and she has
lost the
been,
complaint.
yes, my lord.
She lost the complaint.
Yes, my lord, but she has been under constant threat from her husband to, my lord, withdraw the case, and she could not go there. My lord. And she belongs from a very poor background, so she could not go there and for the case, my lord.
Why she is staying in Guwahati now?
My lord, she is staying here as a tenant, my lord, somewhere in a rental place, and she is working as daily wages, my lord.
Why she left her parental house also?
My lord, all of them are residing here now, because her husband used to keep threatening her. my lord. She is under constant fear, my lord.
Then we'll issue notice at
Yes,
the
ma'am.
stage.
So my lord may kindly transfer the case to Kamrup Metro or
No, without hearing the other side, how order passed?
Okay.
Because this is the case wherein you lost the complaint before which court now? Civil judge?
civil judge, my lord.
Dhubri.
Yes, Dhubri, civil judge, junior division number 3, Dhubri.
Yes, Dhubri. So you lost the complaint, hearing the other. Without hearing the other side, pass any order.
At least, my lord, stay the proceedings
You've lost the FIR and you want to stay the proceeding. Why?
before the
You
next
lost
day, my
the
lord.
case. You lost the complaint and why you, it's not the absurd thing. It's good. You may file a petition seeking time or adjournment, stating your inconvenience on your part that you could not come or you cannot come to before the Dhubri court to depose the matter. There may be reason. That may adjourn.
Okay, ma'am.
Card, Mr. You are Mr.
K. Ahmed.
Card, Mr. K. Ahmed. Counsel for the petition. This is an application. It's section 27. Section of seeking transfer of complaint case. That is CR 77/2021. Pending before Court of Civil Judge Junior Division number 3. Submitted by Mr. Ahmed that though she lost the complaint at Dhubri, but presently she along with her parents are staying at Guwahati and due to continuous threatening from her husband, she could not even appear before the learned trial or with that the notice be issued to respondents to registered it as real process. This team accordingly. Fifteen 9 won't reach, I think. Huh? Your husband's address is?
My lord, he is from Dhubri itself.
He is from Dhubri. So if it can reaches by 15/9 or 16/9, then it's okay. Otherwise, maybe or 2 weeks after 2 weeks, it will be listed. This the matter accordingly after 2 weeks, and you take steps within 2-3 days.
Always.
6.
May I please, your lordship?
Yes.
My lord, here in this case, lordship, the petitioner is convicted under section 138 NIA. Trial court lordship has sentenced him to fine of rupees 3 lakhs. Loan amount, alleged loan amount was rupees 2 lakhs. And in default lordship, SI for 1 month in default. That in the appeal lordship, that has been modified and the amount has been reduced to 2 lakhs.
2 lakhs.
2 lakhs. And against this lordship, this revision petition is filed. And basically, lordship, here, lordship, the amount which she is alleging, that was, lordship, check was given as a security. Because the present petitioner, she was the president of the benevolent fund of Puja Committee. 2 lakhs rupees was invested by the complainant. And after that lordship, as she desired lordship, check amount of rupees 2 lakhs was given. Subsequently, that amount has been paid to her. But that check lordship, she told that the check has lost. And subsequently, she lost this complaint. In fact, lordship, the amount which she was the lordship invested, that entire amount has been lordship given to her along with the interest. But basically, lordship, there is no agreement or no documents to show that the loan amount was given. There is no witnesses to that effect also. And that apart, lordship, there is financial capacity, lordship. She was as a housewife. And she has saying that she had given lordship rupees 2 lakhs. The other points are also there, lordship.
This
May I
petition
say,
is,
lordship?
this revision is lodged by whom?
My lord,
One Anjali Roy.
My-
One Anjali Roy lodged this revision. This instituted who? Anjali Roy? কোনটো case করে আছে?
my lord, may I pay, lordship? At this stage, lordship, notice may issue and execution of the order that may be stay. MP
No, you are
order that
saying
is,
she lost the complaint now. She is an accused.
lordship, she invested rupees 2 lakhs.
No,
Lordship.
no, whatever she in NIA case, she is the accused.
Present petitioner was the
Who is the present petition?
present petitioner, lordship, Anjali Roy.
That's what I am asking. Anjali
Yes.
Roy is the accused.
Accused.
Ah,
And Bani Boru Sharma, she was the complainant. The amount of 2 lakhs lordship that was invested by Bani Sharma.
where is the order?
My lord, order judgment page 12 is the trial court judgment.
Hmm.
That is page 12 and really conviction part lordship page 25. The check was issued not to discharge the legally enforceable debt.
There are judgments wherein it has been held that even the security checks can be considered.
Yes, that is there, but
That is there.
there are
What
some
basis the security check? So, but that is that there are judgments.
other
Cannot
judgments are also there, lordship. There are so
explain
many
yourself saying
judgments.
that it is a security check. Anyway,
Check is not disputed. Check was given as a
no,
security.
you cannot abstain yourself saying that the case is a check was issued as a security check. Security checks can also be considered now. It's not a case, but
Yes,
your
but
case may be
yes,
different.
that is correct, lordship. But the whole amount, lordship, check amount, including lordship, the interest amount was paid to her.
Appeal was passed on 29/7. Order.
Yes. And appellate order 29/7.
Then revision petition was filed on 18th of August,
Well,
within time.
within that.
Have you filed any extra IA or here you have prayer?
No, lordship, I have made a interim prayer, lordship, page 10.
Page 10.
Hello.
Mr. Right. Part Mr. M. This is an application. Mainly. It's submitted. It is submitted by Mr. Bhatt. In the judgment and order by the learned CDM Bongaigaon, the present petitioner was convicted under section 138 of the Act and sentenced to pay rupees 3 lakhs in default 30 days SI for 30 days. However, the appellate court, the judgment order was modified and the petitioner is asked to pay, was directed to pay rupees 2 lakhs as a compensation in default SI for 1. The appellate order was passed on 29/7/2025 and within the period of limitation, the present revision has been filed. Mr. Khan accordingly submitted that execution of judgment and order dated 29/7/2025 may be stayed of its suspended till disposal of user. Next part. Considering this submission made by the net petitioner, the execution of order dated execution of judgment and order dated 3/6/2023 filed by learned CGM Bongaigaon in NI case number 06/2021 as well as order dated judgment and order dated 29/7/2025 passed by learned sessions as Bongaigaon in criminal appeal number 11/2023 is hereby stayed of its suspension till the disposal of the present review. Also issue notice to the respondents to register AD and as usual process. Petitioner will take necessary steps within 2-3 days. Further, call for the case record. Also call for the case records. List the matter accordingly after 4 days.
Awesome.
May it please your lordship. My lord, this criminal revision petition, my lord, directed against the judgment and order dated 30/5/2025, passed in criminal appeal, upholding the judgment of the trial court. My lord, the complaint is based on the vague and omnibus allegation. The DB, my lord, domestic violence complaint, my lord. It's absolutely based on mere allegation, and there has been no corroboration of the and proof of the allegation, my lord. There has been no physical, verbal, or economic or any kind of abuse, my lord, as defined in the act, my lord. My lord, even the trial court, my lord, lordship may kindly have a look at page 71, paragraph 59. The trial court is also not sure whether any violence took place or not. Page 59.
69.
59. Sorry, page 71. Page 71, trial court judgment, paragraph 59. So, my lord, husband, he is to pay the maintenance, etc. But that should be, my lord, his commensurating to his income level, my lord. That is also to axis as held by the appellate court, my lord. That portion, lordship will may kindly have a look at 22,000 monthly maintenance, 11,000 house rent. A part of that, 1 lakh compensation. His salary is not supporting that amount, my lord. That is the point, my lord. My lord, at this stage, my lord, is to pay all this, my lord. We are not that, my lord. Let this allegation, whether allegations are based on um, correct or not, that part we want to challenge, my lord, the propriety and illegality, infirmity to we are soft here, my lord. So my notice may go at this stage. Parents are implicated in the case, whereas the respondent never stayed in the shared house or parental residence. Stayed in the rented house along with the husband, the petitioner. So there is no, my lord, allegation of domestic violence is broke, my lord. Never stayed in the domestic and maintaining a domestic relation with the parents also, at least.
So this is a domestic violence. So at this stage, at best, we can issue notice.
Well,
And you need the case record also, I think. A case record can be called for.
well,
Pardon, Mr. A.L.C. Patil. And also, no, Mr. Ada Kaushik, an additional PP appearing for the state respondent. This is an application of section Swenson against the impingement judgment and order dated. Challenging the impingement judgment and order dated 24/12/2024 passed in Miss TV case number 05 of 2020 passed by Lane JMFC Lakhimpur, Kacha. And
my lord, we have
also challenge the order of additional session just FTC Achar Silchar and passed in criminal appeal number 02 of 2020 dated 24/12/2024 in criminal appeal number 02 of 2025 whereby the order of Lane GMFC has been upheld. Next, para issue notice to the respondents to register negligent process. No formal notice is required to be served on state respondent number 2. Also call for the DCR. This is the matter accordingly. 4 weeks will do.
well. Keep lovely.
Material loss.
Yes.
In this case, my lord, your lordship, 3 witnesses were examined. And all the 3 witnesses supported the case of the accused, but did not support the case of prosecution. So ultimately, court closed. And your lordship, kindly see page 50, madam, 50.
50.
50. Two 625. Your lordship got it.
Yes.
2625. No PWs turned up. Suppose someone issued to the witness personally through OC, but the same was not returned. Perusal of the case record and 164 statement of the witnesses personally reveals that the accused person took the victim and him to another house and asked about the relation and slept him. On the other hand, the victim in her evidence deposed that one day when she, along with Hussain Ali, returning from the Dharna Sabha, then the accused person restrained them and then Hussain Ali fled away from the place. She further stated in her evidence that Hussain Ali directed her to give statement against the present accused persons before the magistrate. Considering the fact and circumstances as well as considering non-availability of medical report of the witness Hussain Ali, this court is of the opinion that the case may be disposed of without taking evidence of other PWs, including medical officer and IO, without causing prejudice to any party. Then, hence, your lordship, hence the evidence of witnesses, Hussain Ali is dispensed with and further prosecution evidence of the case is closed, the case shall proceed for custody. Court proceeded, then it was fixed for examination of the accused. Then court reopened the same again, saying that there is a doubt whether the victim might have been influenced. On that ground, he is reopened, saying that all the witnesses are to re-examined again. Your Lordship got the point. Now take to page 56, my lord. The impugn order which is there. This should make clear one. So magistrate, one closed matter, it cannot be reopened by him, madam. Upper court, superior court may do it, that is another aspect, mine. But he cannot, madam, reopen it. Now page 56, the impugn order, madam. Accused are present. Today was fixed for, your Lordship, today is fixed for the statement of the accused persons. I have gone through the case record and found that the case is very serious in nature, as because there is an allegation of gang rape upon the victim girl who was aged about 16 years at the time of incident. Medical report did not find anything. Next day medical was done. During investigation, the IO produced the victim and one friend of the victim, and their statement was recorded under section 164. During course of trial, your Lordship can note, evidence of 3 witnesses are examined, including the victim, but friend of the victim was not yet examined. The victim did not support the prosecution case. However, she was not declared hostile. On the other hand, the victim gave statement before the magistrate which is seriously incriminating against the accused person. Considering the serious nature of the offense, this court is of the opinion that there might be force or inducement upon the victim for procurement of her evidence. Therefore, the case would not be closed at this stage, already closed. All the witnesses should be examined before final decision in such a serious case. The victim should be recalled and re-examined after removing all kind of threat or inducement from the accused person. Then all other witnesses shall be examined. Hence, the case is again reposted or evidence of the summons to victim's violence. Your Lordship got the point, my lord. Now, if you also kindly look to page 43, what is the victim deposition, my lord? Victim deposition. Page 43. Page 43, my lord. Informant is my brother. About 1 year ago, one night at 4 o'clock, I went to a religious congregation near my house with my boyfriend Hussein Ali. Hussein Ali is not before Lordship. From the religious congregation, my boyfriend Hussein Ali and me were going on foot to my elder sister's house at Dovary. While we were on our way, a few people on the road stopped us and asked us where we were going. They threatened us. Hussein Ali ran away from there out of fear. Hussein Ali's house is in Bamungao. After that house, people left, and I entered a nearby house belonging to a Muslim person. Further examination in chief, your Lordship will get page 47. Your Lordship, page 47. I already deposed my evidence as PW1. Today I came to the court along with my father. During investigation, I was medically examined by doctor immediately after 1 day of the incident. I was also produced before the magistrate, and my statement was recorded under section 164. Cross-examination. Mr. Hussein Ali, who was my friend, told me to give statement against the accused before the magistrate. And hence, I gave my statement before the magistrate against the accused. Nobody committed rape of so-and-so upon me. I have no allegation against the accused. Victim. Then victim's father, my lord. Next, PW2. My son, Abdul Rashid, is the informant. The victim is my daughter. In the year 22, one night, my daughter went to attend a dharmasala in our locality along with her friend Hussein Ali. Leaving the Dharmashala, my daughter and Hussein Ali went to another village. Then the villagers inquired them and prevented them. Then Hussein Ali fled away from the place. My daughter was taken to the house of the person of that locality. After getting information, I went to that house and brought back my daughter. Hussein Ali instigated my daughter to file a case against the accused person. According to my son lodged an FIR, I have no allegation against him. Same thing, PW3, my lord, brother of the same line, my lord. So thereafter, the court closed the evidence file. Now the court suddenly says that there may be folks, maybe that I think, my lord, subject to your lordship, it is not a, my lord, it is not there. 311, my lord, re-examination can be done only when there is a just, for a just decision, my lord. So I think, my lord, your lordship may interfere in this order, my lord. Notice will go to the victim, that might have informant. In the meantime, operation of this order may be stayed, otherwise, might have. That's what I'm there.
Under section 311, because my learned senior is before this court challenging this order, my lord. But he has stated before the court, these are not before this court examination. He has to show that what is the illegality in this order.
What is that?
Illegality in this order. Because court under section 311, court can, for just decision, my lord, court can do, my lord, recalling a witness or re-examination before, my lord, completion of the trial at any stage.
Yes.
Closed. So there is no illegality in my view only in this order. And this is a POXO case, my lord. At this case, notice should go. After hearing the other side also, court may consider a stay or not.
But there is just, my lord, your lordship will have a just decision, my lord. 311, I submitted, my lord. Can do it, my lord. But whether after closure of the evidence, on the face of the finding of the victim,
My lord, if
other, my lord.
my lord, senior friend is
Just,
relying on
just a
decisions
judgment.
and all, then I also need some time. I will also play some.
No, that, but my, because case is fixed on 299.
At this stage, no stay, my lord.
There are 2 points. Now say court has the ample authority or power to
Yes.
re-examine under 311. That is
Yes.
also Mr. Chair.
Yes, I am saying, my lord.
Yes.
The question in here case is a bit peculiar or bit different
Bit
because,
peculiar. Bit peculiar.
because considering the evidence on record on oath, that on oath
Yes.
of the 3 witnesses, the evidence was closed.
Yes.
With an observation that they are not supporting the prosecution.
Yes, that is gone.
Or under the threat or pressure of one Hussein Ali. Yes.
Yes.
So
That
what-
was the observation of the kind of with this observation only, it was closed.
Yes.
That's why, that's how a bit case is a bit
That is tricky,
different.
little tricky
This case.
thing is
But
there.
yes, obviously the point in the by the I mean observed by the subsequent order also, it also cannot be
Rule out.
ruled out because
Yes.
there may be the probability may be there for threatening and all. There may be.
Yes. Because my lord, it might have, my lord, in FIR or 164, you might have, my lord, implicated.
The medical also does not support. Page 32, my lord, medical report.
But-
Gang rape allegation, nothing was found.
It was a gang rape, na?
Page 32, medical report. No injury, nothing.
But that aspect, my lord, in this.
No, that I am
record will have to
only
see,
for
my
the
lord.
interest of justice, my lord, because ultimately once it open on 29 it is fixed. If evidence starts, then ultimately, my lord, it's not going to be prejudiced. So everything become infectious, man. It's the case, and my your lordship page, Ratolnar I have given, my lord, paragraph 19 and 20. Just, the power is there, your lordship already understood, your lordship experience, madam. Power is there, I am not denying, man. That you have to justify why. It cannot be said that, madam, once you closed it, being satisfied that no further witness is required. Then again say there may be some force or something, madam. On oath she freedom. So I leave to your lordship, and I think it is a case for your lordship interpretation.
Second, they can take time, my lord. Second, it is not.
Time may not be given because court has taken
Their
a view.
observation may, or court may give.
That I leave to your lordship, and your lordship understood. This is a case, I think, where your lordship may exercise your lordship.
Mr. H. Chaudhary, the senior advocate, assisted by Mr. H. Mr. Arthur Pochiti, Director, update on this position, whereby the order dated
Goes to the report. Goes to the-
I passed by learned special judge, a special case number 21, bracket of B, 2022, recalling the witnesses for re-examination. Next, to notice to the respondents to raise their case and no formal notice is required to be served on it. Copy of the petition may be served during the course of the day. Very hard of the interim reading. It is submitted by Mr. Chaudhary that the learned special judge by its order dated
Page 50 is the close. And page 56 is in order.
2025 had closed the prosecution evidence, fixing the date for a recording of statement of the accused persons with an observation that all the prosecution witnesses, that is it was PW 1, 2, and 3, did not support the prosecution case, rather they deposed in favor of the accused. However, but subsequently, without citing any ground or reason, the learned same court by its order dated 2/8/25 recall the witnesses, especially the victim, for further examination with an observation that under threatening the victim and the other witnesses might have deposed in favor of the accused. Accordingly, it is submitted by Mr. Chaudhary that that the board has the ample authority and power to recall the witnesses under complying the provision of 311 CRPC only for the just decision of this case. But here in the instant case, the privacy reveals that the evidence of TWs were closed as they did not support the prosecution case, especially by the vital witnesses of this. In view of this, he prayed that the execution of order dated 2/8/2025 may be stayed till disposal of the present revision petition. Next, but Mr. Kaushik Dilan and additional PP submitted in this regard that prima facie it reveals that there is no illegality irregularity in the order dated 2/8/2025 recalling the witnesses by the learned special judge. He further submitted that court has the power to recall the witnesses at any stage of the case if it finds necessary for the thus decision of the case. Accordingly, Mr. Kaushik raised objection, submitted that the order of 2/8/2025 may not be strict at hearing the submission made by and also both considering all aspects of the case. The order operation of order dated 2/8/2025 is hereby stayed till next date of also call for the another scan for the PCF report. We will do the need is the matter accompanying after 4 weeks. We have stated if better, it will be listed after 4 weeks. Till next date of listing only, it has been stated.
And a notice to respondent to.
Yes, yes.
To as procedure.
Yes.
Obliged to us.
May I please, Your Lordship? We are in this petition, Lordship, we are challenging the order dated 31/7/25 passed by the learned Principal Judge, Family Court number 1, order at page 16, Lordship, page 16A.
Page 16,
16,
61,
16A.
16,
Lordship, 16A.
1. No, no, page number,
Page number 16A.
116.
16, page 16 is a typed copy.
Yes,
And 16A is a relevant order, Lordship.
yes.
Lordship, what happened, Lordship? This order has come up based on the order, means the order passed by the division bench of this honorable court, which is at page 40, starting from page 43, Lordship. That's the matrimonial appeal, Lordship. That's filed by the petitioner of the present petitioner, by the present petitioner. The relevant page, that is page 43, Lordship. Lordship, if Lordship turns to page 46, Lordship, of that order, Lordship, page 46, that is third paragraph, Lordship. May I read, Lordship? It is therefore directed that the appellant shall pay a sum of rupees 6,50,000 towards the permanent alimony to the respondent, less on amount of rupees 4 lakhs, which has already been deposited before the registry of this court pursuant to the interim order passed by this court. The appellant shall also bear 50% cost of the education of the minor child and shall also continue with the insurance policy taken by him in the name of the minor daughter, being policy number so-and-so, so-and-so, so-and-so with the sum assured of so-and-so. The appellant shall also continue to pay the maintenance to the minor daughter as directed by the court under section 125 CRPC. Lordship. Based on this order, Lordship, the appellant has continued to pay the maintenance as well as the 50% amount of the what he is entitled to pay, Lordship. The intention of the petitioner is not clear, and it has been reflected from the order passed by this honorable court in page 49. That is, one IA has been filed by the petitioner, because whenever the payment is to be made, payment is to be required from the petitioner, by the present petitioner, the respondent does not inform him. Instead, she used to approach the honorable court, and based on the honorable court order, she used to take the payment from the petitioner. Lordship, this is reflected in page 49 of the present petition, Lordship. This one, third paragraph. On a specific query, Lordship got it, I suppose. On a specific query made by this court, the applicant counsel would not point out any material available on record to show that the respondent was duly intimated about the amount to be deposited in compliance with the directions contained in the order dated 9/4/14. If that be so, the stand of the respondent in the matter cannot be held to be entirely untenable. Be it as may be, on the request of so-and-so, the matter stand adjourned for 3 weeks so as to enable the applicant to take over necessary steps in terms of the order dated so-and-so. If so advised, the applicant is also granted liberty to file additional affidavit bringing on the subsequent development on record, and the same is deemed to be necessary. Again, on page 51, Lordship, first paragraph, Lordship, page 51. After, may I read, Lordship? After hearing the submission advanced by the learned counsels for both sides, it transpired that the respondent is aggrieved by the fact that the appellant, without any intimation to him as regards the actual amount of expenses which is required to be borne by the respondent as 50% of the educational expenses of the child, directly approaches this court seeking judicial order. If that be so, the matter needs to be looked into by both the parties and sorted out with the intervention of the learned counsel for both the sides. Lordship, taking advantage of this judicial order, Lordship, the respondent used to file cases in the High Court and take the amount from the court on itself. Now the thing is something different, Lordship. Now the petition means the girl on which the 50% education amount is to be paid by the petitioner has become measured. I have annexed attached the birth certificate of the minor girl, Lordship, which is annexed to page 18, Lordship. Her date of birth was 21/9/2006. She has got measured on 21/9/24. She has attained the 18 years of age. Now the question is, Lordship, if any amount is to be required, is to be paid by the petitioner, he is ready to pay. But provided the payment should not be go to the respondent. It should go to the petition, means to the girl, since he is a major now. Taking advantage of the minor of the girl, means age of the girl, the respondent used to harass the petitioner lordship. So the even in Lanit Family Court Principal Judge Family Court number 1 has also ordered to pay the amount to the respondent. So lordship, this order, and moreover lordship, the petitioner is also retired on 31st March of this year, lordship, 2025. He has retired. So taking huge burden of this amount is not possible on the side of the petitioner, lordship, at this stage, lordship. So I am praying for that. Let this order be stayed and notice may go, lordship.
What order? What order should be stayed?
That order dated 31/7/25. Because he has paid the maintenance amount, lordship. If lordship turn to page 17, it's reflected that opposite party has deposited rupees so and so towards monthly maintenance allowance, which has been received the same by the petitioner. The maintenance amount towards the girl he has deposited. Petitioner has not failed in depositing the maintenance amount. Only this amount, this order may be stayed, lordship. I am praying at this stage, lordship.
What was the order, Chief?
Lordship, order is, may I read, lordship? Parties are present, heard the sides on the prayer of the petition number so and so. It is agreed upon by the parties that the area amount of the cost of education till March 25 is accumulated to rupees 3,14,627. The opposite party is directed to clear the area content of education cost of education by next date on 29/8/25. That is, by tomorrow he has to pay an amount of rupees 3,14,600.
Why this so much? The huge area amount is accumulated. How and why?
Area amount was
One
accumulated.
hand you are saying that you are paying the maintenance
Maintenance
amount
amount.
50% of the cost of the so and so.
Yes, yes, yes.
But why it has been accumulated to more than 3 lakhs?
Lordship, the thing is that she used to give the receipt. I mean, she used to file a case in the High Court as well as in the Family Court regarding the maintenance, means the 50% cost of the education. When the petitioner used to ask for the proper money receipt, she used to produce but the money receipt which she is produced is not relevant, means is not.
So why don't you approach these things that you will pay whatever you are going to pay
Lordship,
before the court itself?
Lordship, that we have already approached, Lordship. In fact, I'm sorry to say, on 31/7/25, I was present in that court, Lordship, before the learned principal judge. Lordship, here it has been written that as agreed by both the parties. At that moment of time, the petitioner was not agreed, Lordship, but the learned family court does not want to hurt the petitioner side. He said, you just keep calm. We are listening to your wife. Then only you argue. After hearing the opposite side, he said that I will pass the order later on. In that way, Lordship, we have to keep mum, Lordship.
There cannot be any stay, such a stay order cannot be there. You just do one thing.
Otherwise,
You
Lordship,
admit that there may be an area, may not be 3 lakhs, more than 3 lakhs, but there are some.
yes, Lordship, Lordship,
So you pay 50% or something, you pay time before the court, and in the meantime, we'll see the record.
Lordship, yes,
So you are
Lordship,
challenging the order of that order only.
only
So
that order.
without anything, how can we say that there was an area was there, error was not there?
Because
Whereas we don't have anything.
yes,
Now
Lordship.
it is your submission that that was the area. Area was not there, and she used to file a case before High Court as well as this
Yes, yes.
family court, and used to receive the money and all. So if that being this, so then before the court itself you have paid. You
Yes,
paid
Lordship.
the money before the court is at
Yes.
the court. Their record will be there in in the order sheets before this.
Yes,
this,
Lordship, yes.
this column. They'll be received so and so money, so and so. They'll be definitely there.
Lordship, everything is clear, Lordship, because what I am praying at this stage, Lordship, because the petitioner on the application filed by the respondent regarding the amount which she is claiming, she used to furnish us the relevant money receipt and the receipt, Lordship. At that moment of time, the receipt which are being objectionable, we are objecting to that receipt, Lordship. And out of this, now also the petitioner is praying, means petitioner is not saying that he will not pay the entire amount. He said that, yes, since I am retired, I am superannuated from service, but since she is his daughter only, So he,
raised this point that your daughter has already become major. You are
Lordship,
going
that has
to
been
retire. These things are there because there may be alteration, modification of the order, even order passed.
that has been already been placed before the learned principal judge, Lordship.
Say, probably you are saying we are not, before us, we don't have.
Yes. Yes, it's not on record, Lordship. So at this stage, Lordship, if Lordship doesn't stay also, at least petitioner may be directed to pay at least 1 lakh of rupees, Lordship, because beyond that, he won't be possible at this moment of time, Lordship. Because he has already been superannuated. Out of 3,14,000, he may pay 1 lakh of rupees, Lordship. That he also doesn't agree that means he will not pay a single penny because he says that he will pay the money, but the claim should be raised from the daughter since she has attained her majority. Every time.
She is pursuing her study and all, she needs money, na?
Yes, definitely, Lordship. Definitely. We will pay, but not this amount, Lordship. At least at this stage, I mean, amount of 1 lakh may be granted, Lordship.
I- Then- So in Challenge order date 3107 passed by Senate Principal Judge Family Court number 1, Complete M. 1 in criminal execution case number 137, whereby the petitioner is directed to pay rupees 3 lakhs 14,697 to the respondent on or before 29/8 issue notice to the respondent to register AD and the process. Further considering this submission made and before the petition. Also considering the fact that the petitioner is going for evaluation. The petitioner is hereby directed to pay rupees 1,50,000 as the ADR amount towards cost of education on the next date of this thing. And however, there is no order dated 31/07/2000. However, no stay will be operated on the order dated 31/07. Please the matter after 2 weeks as on a date will be fixed. Okay, you pay 1,50,000 tomorrow, and rest of the matter.
Lordship. Declare.
2 weeks.
Wait, please, my lord, this is a revision application, my lord. Against the judgment and order dated 10/5/24, my lord. Passed by with all respect, my lord. Additional session judge, Udalguri, my lord. Upholding the judgment of the learned trial court, my lord, convicting the petitioner under section 420 of the IPC and sentencing him to suffer RI for 2 years and pay a fine of rupees 1,50,000. That, my lord, that judgments have been challenged by the petitioner here in this application, my lord. Primarily, my lord, lordship will kindly appreciate the learned trial court as well as the appellate court resorted to section 72, comparing the handwriting of the petitioner in the promissory note itself and thereby convicting the petitioner in the trial as well as by the appellate. So he is on bail, my lord, right now. So lordship will kindly allow him to remain on previous bail, my lord. And the sentence is passed, my lord, may kindly be stayed.
For that, you have filed it separate?
I is there, my lord.
Yes.
LCR may be called. TCR.
TCR.
And it does the learned. I could also for the. So are a positive learned. Yeah. this interlocutory, has been filed for suspending the judgment of court past in criminal 12 of 2024 by an additional session judge Pudalguri upholding the conviction and sentence passed by learned CGM Pudalguri in connection with GR case number 11204 corresponding to PRC case number 903 of the 21 submitted registered task that accused is in his own bail and his previous prayer for and accordingly paid to remain in his previous bail till disposal of the connected revision petition. He also paid for the suspension of sentence operation of he's also paid for suspension of execution of sentence passed in till the disposal. Next, fortunately, that I can be days now. In view of this, the judgment and order related to it passed by an additional session service. The penal so and so is hereby state like suspended.
Sentence may be suspended, my lord.
Yes.
Because my learned friend has written as my lord judgment in order to be.
No, only sentence.
Separatized.
Sentence.
Higher
Will be suspended till disposal of the petition, and the petitioner is also hereby allowed to remain on its previous bail. With the above observation, the highest and are with criminal reasons. Say hard change. This is an application against your judgment and is there any, I don't think any the respondent is there, private respondent?
No, my lord, state of Assam.
State is out. Call for this here. List after 4 days. Will be listed after 4 days.
Deeply obliged. I am obliged.
May please, your lordship. If you say revision against a charge order, I'll just read 2 documents, your lordship. Your lordship will see whether there's a case for charge or not. My lord will kindly come to page 13, my lord. Is the FIR, my lord.
Yes.
May I read, my lord?
Yes.
Sir, with due respect, I beg to state that I, Sri Mohananda Sharma, am a resident of so-and-so place. My daughter, Srimati so-and-so, aged about 17 years, used to take karate instructions from Mohammad Sofikul Rahman, aged 24 years, resident of so-and-so. Sofikul Rahman is the petitioner, my lord. And while giving karate training, he tried to establish illicit relationship with my daughter, and he has been causing mental harassment to her. As we belong to the Brahmin caste of the Hindu community, this relation cannot be accepted easily by us under any condition. Sir, with reference to the above mentioned matter, I humbly pray that you may kindly investigate the matter, punish the guilty, and thereby help us. This is the father's FIR. Now, your lordship will kindly come to page 20, which is the 164 statement, 183 statement of the victim, my lord. Married, my lord. I have known Sofikul Rahman for the past 3 years, and we have a love affair. He is my karate teacher. Since he is a Muslim, our love affair has not been accepted by my family. Sofikul has never tried to establish any physical relationship with me. He has never tried to forcefully exert himself on me. When I told him that it is not possible for us to ever be together because he is a Muslim, he then said that he would convert to become a Hindu. When I informed my mother and father about his statement yesterday, my mother and father agreed to talk to his family members. Sofikul has never misbehaved with me. Sofikul has not caused any harassment to me. This is all I have to say. This is the 183 statement. Now, charges have been framed under 78 BNS and Section 12 of the POCSO Act on this statement. That order is at my lord page 27. Right. One can understand, my lord, police submitting charge sheet in such cases. Why the court has framed charge even after this statement, my lord? That is a mystery, my lord. No allegation of harassment, no force, no physical relation, nothing. And Section 78 is stalking, my lord. Section 78 BNS stalking. That if the
RYPC, there cannot be any case of
stalking
Right.
and
He was
with him. And sexual harassment is also nothing is there to show sexual harassment, my lord. So at this stage, let my lord notice go, record may be called for, my lord, and other proceedings may be stayed, my lord.
Yes, Mr.
Going by this 164 statement, my lord, there is
We have a there may be. But otherwise, it seems that.
it seems.
Pardons from that's the one thing after the no, pardons are not worship with an addition then application it's with collecting the order of framing charge. It is 680 whereby the charge was formal charge has been framed against the accused petition under section 68 with section 12 of the also. Issue notice to the response registered in the process. No problem notice is but status on month. Copy of the petition may be served during next paragraph of the interim. It's submitted by Mr. that the petitioner is himself. He has not committed any such offense. Also, from the statement made by the section 183 the RPC, 183 PNSS, it is it reveals that there is no such allegation of sexual harassment, stalking, etc. against the present petition. But without considering these aspects of the court had framed charge against this petition. Accordingly, we submit that further proceeding in the present case may be stated with disposal of Mr. Kaushik to the next additional PPs that at this stage it may not be any stay of recording. Considering the subject with that and and the is available. I find it a big case to pass the to stay the further property against excellence or pending the learned special excellence in connection in next time. This recording.
I'm deeply obliged.
We don't understand it.
Motion. May please, your lordship. But we have challenged, my lord, an order of charge, my lord. But the lordship may kindly see the FIR at page number 28. 28 is the FIR, my lord. May I read the FIR, my lord? In the middle, my lord, 15 জুলাই তাৰিখে কুমাৰীকাটা বনাঞ্চলিক বিষয়া বীৰেন বড়োৰ নেতৃত্বত আৰু শ্ৰীযুত অমল কলিতা সহযোগত কুমাৰীকাটা আঞ্চলিক বন বিষয়াৰ কাৰ্যালয়ৰ পৰা বন বিষয়াৰ কাৰ্যত নিয়োজিত বলেৰো বাহন নম্বৰৰ গাড়ীৰে কুমাৰীকাটা জালাহ ৰোডৰ স্থায়ী ফাৰ্নিচাৰ দোকানত বিক্ৰী কৰি থকা মুহূৰ্তত স্থানীয় ৰাইজে প্ৰশাসনৰ লগতে হাতে লোটে ধৰিবলৈ সক্ষম হয়। ঘটনাস্থলীৰ পৰা 3জন বন বিষয়াৰ কাৰ্যালয়ত নিয়োজিত ব্যক্তি প্ৰশাসনে কৰায়ত্ব কৰে উক্ত কাঠখিনি প্ৰায় 10 দিন আগতে জব্দ কৰিছিলে পিছত আজি কাঠখিনি বিক্ৰী কৰিবলৈ যোৱাত ৰাইজে হাতলতে ধৰে। So the allegation was that all the petitioners are employees of forest department. So while they were attempting to sell some timbers which were earlier seized, the public nabbed them and handed over them to the police. That is the allegation, my lord. And the FIR was registered under 198-316-535. Basically, it's a case of breach of trust. Now, the police, after investigation, submitted charge sheet under similar sections, my lord. The lordship will kindly see page number 30. That is the charge sheet. And page number 80. Page number, my lord, 38. 38. Second paragraph, my lord.
Yes.
In the middle, my lord, in course of investigation, it revealed that although Biren Boro, Omol Kolita was not present at the moment, but they knew everything regarding the selling of seized timbers in a furniture shop for the construction of alna chair bed. Three persons, namely Robiram Boro, Dhanjit Nath, Moinul Haq, had gone to the shop of by a Bolero pickup vehicle bearing registered number so and so for selling it to the shop. In course of investigation, district forest officer also replied that an auction had conducted of timber sale on 27/7/2023, but due to non-availability of bidders, some quantity of timbers were still remaining unsold, which were lying at Kumarikata Range Office campus. It means the timbers were carried by the forester, was not auctioned by the forest department. Here they said that, my lord, they attempted to sell those timbers by way of auction. But, my lord, since in a case of, my lord, criminal breach of trust, first, my lord, there must be entrustment, my lord. Here, my lord, they have not been able to produce any material regarding the entrustment. That is, if they were indeed seized by the officials, my lord, then there would have been a seizure list, some GD entry, no record whatsoever, my lord, nothing. And even if your lordship will kindly see the seizure list at page number 70, my lord, this is a seizure list. It says that only 30 kb timber were seized. No records of any other seizure is collected by the IO in the instant investigation, in this present case. Then, my lord, I have.
But the allegation is that those forest timbers or whatever were the seized article.
Were all earlier seized.
Earlier seized.
Earlier seized.
So that's why this seizure list of 30 kb.
This is the present seizure. Seizure in the present case.
This case.
Yes, but they ought to have collected the
earlier
relevant material regarding the earlier seizure to show that indeed those timbers were the very timbers which they were attempting to sell in the present case. No such records have been collected by the IO. So, Magistrate to cognizance, my lord, will kindly see page number 71. Before that, my lord, I have annexed all the statements which have been submitted by the IO with the CS, my lord. There are 161 statements. I have all annexed, my lord. Now, lordship will kindly see page number 71. This is the cognizance taking order, my lord. Cognizance have been taken under similar sections 198, 360, 35. Thereafter, my lord, at page number 72, we filed a petition, my lord, seeking discharge, mentioning all these things, my lord, before the magistrate, my lord. Now, lordship will kindly see some papers, my lord, which I had submitted in the, it will be in the record, which were, my lord, not annexed.
Is that?
Yes, yes. Lordship will kindly see 17.5, order dated 17.5. On this day, my lord, we filed this petition, praying for discharge. 17.5.
Yes.
17.5, my lord. Thereafter, my lord, next date was fixed for hearing on this petition on 11/6. Next date, lordship, 11/6, my lord.
The 17.5 itself, we have filed the petition.
Filed the petition. On the next date, my lord, that is 11/6. There, my lord, the court passed an order with regard to the Jimma of the seized vehicle. And lordship will kindly see the last, the next page, my lord. The court fixed 8/7 for order on this petition. 8/7 was the date which was fixed by the trial court for order on this discharge petition. Now, lordship will kindly see the impugn order at page number 80 of this instant petition, madam. The learned court straight away, my lord, framed charges without even considering the discharge petition, madam. Whether, my lord, that petition was allowed, whether that petition was rejected, my lord, nothing is there. Straight away, my lord, the charges have been framed. Lordship will kindly see 80, page number 80.
এটু কি না বাড়ে বন্ধ হয়ে বন্ধ করে দিচ্ছে So without passing any order on discharge
Yes,
petition?
the court frame charges. So not only, my lord, we have challenged this order, my lord, we have also challenged the charge sheet also, my lord. Because we believe, my lord, there are no materials, sufficient materials under section 316 or section 198, my lord, for the IO to have filed the charge sheet, and also the court to have taken cognizance on the basis of such charge sheet, my lord. So we have challenged the entire proceeding of this case, my lord, including this charge framing order. Apparently, my lord, this order is illegal because that petition has not been considered by the learned court below. No mention of anything, my lord, whether it was allowed, whether it was rejected, my lord, nothing is there, my lord.
Lordship. Yeah, my lord, yes, my lord, as per section 262, a petition can be filed for discharge. A petition can be filed for discharge even after, my lord, consideration of charge, my lord. Formal charge, and that if it is there, man, that has to be disposed. That is there, man. Yeah, as per 262, if your lordship may kindly take up.
3-1?
My lord.
316.
262 of BNS, my lord. Now, my lord. Two 63 is the framing of charge, my lord. Yeah.
263 is the framing of charge, my lord. This new provision, my lord, even
This is a new
adds some
provision, my
extra
lord.
words. It says that, my lord, if upon such consideration, examination, it even says that the accused will have to be examined. Now, what is the scope of examination, my lord? That will have to be decided, my lord. But it says that if upon consideration and examination of the accused persons. So this order, my lord, does not reveal anything whether those accused were even examined or not, or any petition, my lord, was considered or not, my lord. Nothing has been mentioned. It says if upon such consideration, examination, if any, and hearing, they will have to be heard. The magistrate is of the opinion that there is ground for presuming that the accused has committed an offense triable under this chapter. Then the magistrate is competent, then he may frame charges.
Because that order, my lord, is not a part of record, my lord. So I have not seen the order, my lord, but order has been passed by the learned trial
Page
court.
number
Page number
80.
Sorry.
That order has been annexed.
Oh, last. That is, my lord. Oh,
He has annexed
This is-
the order
yes, sir,
to
this-
charge.
yeah, this is directly framing charge, my lord. So whether that petition, whether it has been heard
Yes,
or
he
not.
has filed this one loose sheet. Some.
Yeah, yes, my lord. Because if there is a petition, my lord, there has to be an order on that petition, my lord. Hearing on that petition, my lord. If they have made a
What Mr. Das is saying from
Yes.
these sheets, that the petition was kept for hearing,
yes,
and on 11/7, I think, on. As per the
11/6.
submission on 8/7/2025 was fixed for this
Order
on this said petition,
yes,
which was filed by them for paying for discharge.
lords.
And the petition was seems to be heard on 11/6/2025, the discharge petition.
Yes.
But without considering this petition, as per Mr. Das is submitted, that the order of framing charge was passed.
Yes, only.
But you
legal-
don't have wisdom.
Yes, I have not. This is the new. Not. Zimma was given.
Zimma.
Order. 8/7. Taken. 8/7. This
of 8/7.
is 8/7. Directly, it is fixed for 8/7 for orders, my lord. Then 8/7 is, my lord, page number 80 order. Fast charge payment order.
That this petition was not considered.
Let me
See to it
that-
whether it can be.
Yes, madam.
That
Now you have any interim prayer?
Interim, my lord, next date is fixed on 18th of September, my lord, for PWs. For PWs, my lord, evidence.
Instead of kept pending, my lord, it can be given direction for at least make an order.
2 days.
Yeah, yes, then my lord. Otherwise, it's trial will be stalled because so far their conduct is concerned, my lord, there's so far search sheet is concerned, my lord. The materials are there against the petitioner's right.
So, but
Regarding
the question is that he is saying that he is not only challenging the order of 8-7,
it,
but entire
subject to what
charge sheet.
my lord
Yes.
can say, sir.
In that case,
To your
now,
lordship, if your lordship wants to
otherwise we could have
examine-
disposed of the matter by today itself.
Yes,
Yes,
yes, by giving a
without-
direction to the court to.
Yes, but for washing of the charge
Then
sheet,
the
it
record will be
take some
necessary.
years.
then it will be another thing, my lord.
Another.
It's up to your lordship, if your lordship, it's up to your lordship, if your lordship deems it fit to examine the charge sheet, then the records will be necessary. Or if your lordship wants to give a direction to the lower court to pass an order on the discharge
No,
petition.
it's from your document, it basically reveals that the order was, it was fixed for order on 8-7.
Yes,
Yes.
On the said petition
Yes,
for your discharge.
yes.
That has not been passed and the charge was paid.
Yes.
Yes, perhaps,
Mr.
yes.
Goswami also agreed.
yes,
So in that context, we may dispose of the petition today itself,
yes,
directing this way. So, but the question is that you have also challenged or you have
Yes,
also paid for
yes,
washing.
that's,
In that case, too,
that's-
we need.
Because I have objection regarding interfering with the search sheet, my lord.
Yes.
That is-
Otherwise, it's okay, but
Yes.
it's charge sheet if you have to,
yes,
mean-
that's what my lord, if your lordship wants to examine the charge sheet, because we have also challenged the charge sheet, then the records will be
that's what
required.
I'm saying. In that
Yes.
case, we cannot dispose of the matter
Yes.
today. That part Mr. S. Das, the learned contribution, and also part Mr. MP Gusam, the learned additional PP appearing on Mr. This is an application restricting so and so.
To open again.
For watching of the order dated 8-7-2025, passed by learned additional CGM, Baksa,
Let us get pending.
in PRC case number 69 of the 2025. And also paid for washing of the entire, washing of the charge sheet and the entire process. Issue notice to the respondent. No formal notice is required. So, as the state respondent has already entered into their evidence, however, copy of the petition may be served during the course of. Out for the scan copy of the this year along with the case diary. Next. Pardon intimidated. It is submitted by Mr. Das. That the present petitioners are innocent and the case and from the materials in the FIR as well as charge. There is no case that the section and this the section 198-316 subsection 5 of the 3 subsection 5 BNS do not affect against the present petition. In view of this, they have also they filed discharge petition before the learned trial court below, which was accordingly fixed for hearing on 11
11,
6.
6.
11-8.
No, 11, 6.
No, 11-6 it was hard.
Hard.
11-6-2025 for hearing on the petition. And the next date was fixed for passing on order on the said petition. That is on 8-7-2025. But without considering their petition for discharge and without even mentioning about the petition, the charge was framed against the present petitioners, and hence the said order of framing charge is also under challenge. Mr. Das accordingly submitted that till the disposal of the present petition, the further proceeding in connection with case number so and so may be stayed. Next para, Mr. Goswami, the learned additional PP submitted in this regard that the direction would have been given to the learned trial court below for passing the order on said petition for discharge. But as the charge sheet is also, as there is another prayer for quashing of the charge sheet, the TCR along with the scanned copy of the TCR and CD will be required. Next part, in view of considering the submission made by so and so, further proceeding in connection with so and so against the present petitioner be stayed till next date of listing. List the matter accordingly after 4 weeks as on a date.
Kindly record one, my lord, that I have objection regarding my lord, staying of the entire proceeding, my lord. So may kindly observe that, my lord. Regarding my lord, staying of entire proceeding, my lord, I have objections, man. That may be kindly recorded.
However, Mr. Goswami raised objection in staying the entire proceeding against the present petition. It doesn't lie to me like.
Okay, I'm deeply obliged.
Highly obliged. Highly.
Agree. Even a what? Doesn't deliver. আপনি একটা খবর করবেন আগে কিন্তু আমার বুঝতে কালে সব টিভি থেকে না কই পেলো এখন কারণ মানে মিটিং অফ কাকত একটা অফার কালে দুটো প্র্যাকটিস আপনি একটা কনফার্ম এইটা বলে মিটিং সব দীঘলিয়া হবে অহাকালে মিটিং অহাকালে এখন সেম টাইপের মিটিং আছে কিন্তু শর্ট কালি হলে মা বেয়া নাপায়
Lordship, my senior is presently engaged in code number 1. May I request your lordship to kindly pass over the matter for timely? Obliged.
May I please, your lordship? So item 14 of today's list and item 14 of tomorrow's list, also same case. Lordship, take
Item
up the
14 of today's list and item
14 of tomorrow's. Criminal petition 1051, already listed for tomorrow. Same item of the same parties, lordship. I think you take up tomorrow, lordship.
Okay.
Lordship.
item number, just tell us the item number.
Criminal petition 105125,
1051.
listed for tomorrow in lordship's court at item number 14.
It is the matter at the
Adi to
request for the learned counsel for the petition. It is the matter on calculatory notice 29/8/2025 along with criminal petition number 1051.
Lordship. Obliged.
May I please, the Lordship. Lordship, here Forest Department is required.
Sharma is
Yes.
Lordship, here in this case, Lordship, this present petitioners is the registered owner of a truck. His vehicle has been seized in the year 2018. And whatever the Lordship confiscating.
Vehicle was seized.
Whatever confiscating proceeding was started, everything has been rejected, Lordship. Against petitioners was challenged this confiscating procedure. That was rejected. Lordship, now Lordship.
Prayer for Jimma was rejected.
Rejected. Everything has been rejected, Lordship. Now, Lordship, present petitioner filed these petitions before this honorable court. That Lordship, there is a notification, Lordship. Lordship is very much aware about the withdrawal of this case. So, in this case, Lordship, the present petitioner case is completely covered with these notifications, Lordship. And Lordship, similar cases already withdrawn. I have already annexed that documents. A similar type of cases already withdrawn by this state.
In person to that notification.
Yes. And
but whether the notification covers these cases under special act?
Yes, Lordship. I kindly see Lordship case at 23. The relevant portions, Lordship,
page 26. Pursuant to the cabinet decisions dated 11/9/2022, it has been decided to go for withdrawal of the case under section 321 CRPC, where punishment is up to 3 years or fine or both under the Indian Penal Code or any other special act or regulations, Lordship. Regulations registered up to 14/8/2022, except for the cases registered under the following acts. There is whatever exception is there, Lordship. My case is fall under this regulations, Lordship, Assam Forest Regulations, Lordship. Lordship, I have annexed in a similar cases, Lordship. Similar case is already withdrawn. That is page 31. This is the same similar case, Lordship. This is a track was seized, confiscating procedure has been drawn. That is, everything has been rejected, and ultimately, the Lordship, cognizance has been taken on the basis of such sheet. And on page 34, Lordship, page 34, order dated 27/3/23, the may I read, Lord? Accused is absent. Peruse the petitions bearing number so filed by the learned APP series so filed under section 321 of CRPC, praying for withdrawal the instant case as per the notification dated so of Assam. That is notifications. Peruse the case record. On such perusal, it is found that the IO has laid the charge sheet in this section. In this case, under section 41 of Assam Forest Regulations against the accused person. Heard the learned APP, it also reveals that the case does not fall in any of the exception as mentioned in the above of stated notifications. Moreover, it is also found that the matter fulfill other criteria mentioned in sections 321 of CRPC. In view of the above fact and circumstance, the prayer is allowed. The case is accordingly disposed of on the withdrawal. This article, if any, shall be disposed of in due course as per law. The accused is hereby discharged. Lordship, already discharged. Lordship, kindly come to next page. Lordship, thereafter, Lordship, when
Then on the basis of that, pursuant to that said notification, why don't you approach before the learned trial court?
Lordship, what happened in this case, Lordship? Till date, the petitioner did not receive the summons, and the petitioner visited to this concerned court, and also
No, but against you also any case
No.
final report is laid now?
no, Lordship.
Now,
Lordship,
not
here in the year 2018, my vehicle was seized. There is page, Lordship, kindly come into page 18.
No, whatever. The question is that you are the vehicle owner.
Yes.
Your vehicle was seized in 2018. So if the case comes under this forest regulation or whatever, which is not in exceptional matters as per the notification, say why, if you're not the accused, the other accused persons may approach the learned trial.
No,
court,
Lordship, the other cases, Lordship, it automatically withdrawn. But here in my case, Lordship, that still the peasant petitioner are not aware whether the charge sheet has been filed or not. And several times have already inquired this matter, but no response has given the forest department as well as the petitioners already.
So at this stage, till date, you are not in a position to say whether the case has been charged sheeted or not.
No, yes.
So how can you accept that your petition, your case can be withdrawn from the learned trial?
No,
court?
Lordship, I am not saying the withdrawn. I am saying, Lordship, that pursuant to that notifications, Lordship, my case is there. So till date,
What he is saying.
My lord, one thing, my lord, kindly come to page 40, my lord. They have a, my lord, application regarding the withdrawal to the my lord, divisional forest officer for regarding that, my lord, withdrawal of their, my lord, case. My lord, on that, my lord, I have a, I can obtain a, my lord, any instruction whether department has acted upon on this petition, madam. Anything, madam.
This petition was filed before divisional
Lordship,
forest officer.
Yes, madam. Lordship, these petitions, though petitioner was tendered, but the concerned officer did not accept. That's because the petitioner already informed that already informed that other cases. The same case is already withdrawn, vehicle was released, everything already informed. The court concerned officer informed that you have to obtain a court order. So that's why the petitioner is approached before this honorable court.
No, but
There is
our
a right
duty
forum,
is
my
not
lord.
to
Trial court
pass
is
any
that.
order on withdrawal.
Yes, my lord.
This court cannot pass.
No,
any
Lordship,
order
I
on
am, no,
withdrawal.
Lordship, I am seeking the quashing the whole procedure as because, Lordship, ultimately what will be happen?
How many?
No, no, Lordship, I am saying it is not.
You
Lord-
are simply a vehicle owner. So
Yes.
how can you accept that entire petition can be quashed on your petition that he was a vehicle owner? That cannot be.
No, Lordship, I am saying, Lordship, that whatever criminal proceeding, it's deemed, Lordship, suppose today or tomorrow, they will submitted the charge sheet, then that case will be withdrawn pursuant to the notifications. But till date,
Maybe withdrawn, yes.
but so that's why, Lordship, I am deemed to discharge. So now I am deemed to discharge.
No, you are saying that you are not the accused.
No, I am the accused.
Oh, you are the accused.
Yes,
No,
Lordship, I am the owner.
till-
Well, I am the owner.
This beginning of your argument, you are saying that you are the vehicle owner.
No, that's why, Lordship. Whatever case, Lordship, Lordship, after when confiscating procedure has been thrown, notice has been given to me as a owner. And Lordship, in this case, Lordship, I am assuming or presuming that one case may be raised against me. As because, Lordship, whatever other cases I have already annexed, that case was raised against the owner. So I am.
So now what is your prayer in fact?
Lordship, my prayer is that the Lordship, whatever their criminal proceeding, that may be withdrawn as per this notification. As
Who
because,
will withdraw? This
Lordship, no. I am saying, Lordship, one direction may be given to this forest
My
department.
lord, yet, my lord, that application is not filed in the appropriate court, my lord. How this court, my lord, will enter in?
No,
order on withdrawal.
Lordship, kindly peruse one more thing.
Let my lord, that application may be filed, my lord. If my lord, there is any grievance, then my lord, they will come.
But till that, the charge sheet is not yet laid.
Yes, my lord.
That is a, how
Whether-
the court also can entertain the petition because
My lord.
charge sheet is not there.
That is a presumption.
That
On
is a
presumption.
Lordship, kindly one more thing, Lordship. I have already sent another.
This vehicle is already been confiscated.
Yes.
So your prayer is not in connection with the vehicle at present.
No, Lordship, I am saying, Lordship, second prayer is there that at first, Lordship, my proceeding is a goes, then, Lordship, the vehicle will be released. Then my second prayer is there. Lordship, this notification is
Now
covered.
see, there may be some ground for consideration of your prayer. That suppose there may not be any materials to proceed with the case, or there may be some ground for quashing. That can be accepted. But you are insisting on that notification. The purpose of that notification that whatever cases pending before the trial court and all under 321 CRPC, those matters can be withdrawn.
Yes,
So
Lordship.
in pursuant to that petition, except some exceptions are there, other cases may be withdrawn.
Lordship.
But till that case is not yet charged, you are not submitting anything on that regard. You are simply insisting for withdrawal. So this court is not in a
Lordship,
position to pass
Lordship.
any order on withdrawal.
Lordship, my submission is that, Lordship, since 6 years already gone, is still there.
Mr. Sharma, he is saying I do not follow. In fact,
Yes, my lord, that is also I have also that problem, my lord.
on one hand, he is saying he is the vehicle owner.
Yes,
Second hand, next.
My lord, kindly say,
Already confiscated.
my lord.
If matter is already been confiscated, so release of the vehicle, there will be another problem.
Another-
Because matter is already been confiscated.
Mm.
As per him.
Mm.
Now, one hand, he is insisting. And secondly, he is saying the praying for quashing of the entire matter. Without anything, quashing cannot be given. And till now, case is not yet charged. So what to do?
My lord, kindly directly come to the his prayer portion, my lord. 13. Page 13, my lord.
Yes, 13.
Prayer portion, my lord. First prayer is, my lord, the withdrawal of this, my lord, this after this government notification, my lord.
Yes.
And my lord, this for withdrawal, my lord.
Ah.
This is not the right forum.
No, this is the right forum.
No,
This is not the right forum.
Lordship, then,
So, my lord,
Lordship, one
Then
more.
second is the release of the vehicle.
release of the vehicle.
Then-
And my lord, yet my lord, that charge sheet is not filed.
Not fine.
Whether he is charged or not, my lord, at this stage, my lord, we cannot say.
Lordship,
No,
then, Lordship,
cannot say.
one more thing, Lordship, can this court do? Lordship, let them, instruction may be sought, whether such sheet has been submitted or not.
That I can
If-
do, that,
if-
that I can do, that is not, there is no problem. But my lord, for the first prayer, this is not the right
Court
forum.
cannot consider.
Yes.
And second also not cannot be in consideration because
Be considered.
vehicle has already been confiscated. Then how can this really, or
Yes.
it will be
Lordship-
taken in any problem?
Lordship, this is, I think this is.
Suppose it's, your petition is outrightly should be rejected in fact.
Yes.
This is, there's no
And
case at all.
Lordship, Lordship, I kindly.
Suppose propose will come later.
Yes,
on. Now at this
they
stage, we
will
don't
not
have
come.
any.
Lordship, kindly peruse.
Suppose it will be.
Lordship, kindly
in the
peruse
event
wa-
of such it, that will come later on. Now at this stage, there's no case at all.
Lordship, kindly come into page 38.
No case study.
There another representation already sent, Lordship. That representation on
Heard Mr. I hope, the learning council for the petition. And also heard Mr. P. Sharma, the learning.
My lord, I am for my lord, 2, 3.
2 and 3.
And my lord, Kaushik will represent my lord, respondent 1.
1. Ms. Sharma for appearing for assistance, standing council for the department appearing for the respondent number 2 and 3. And Mr. R. Kaushik, the learning council appearing, additional 50 appearing for the state respondent. Decision. Deficit and I don't know. So, একটু বুঝতে পারলাম না। Challenge একটু নাই আর। একটু নাই। একটু নাই। There's nothing, in fact, Sharma. There's no challenge at all. Nothing is there.
Yes.
So how to write is a
Lordship, my limited submission, Lordship. Let the instruction is what, Lordship, whether Sashid has been submitted or not. If not, Lordship, I will withdraw.
So point of Mr. Sharma, the learned standing council for the department, we are asked to take instruction as to whether any charge sheet has been laid in the present case. A report may be called for to that regard. Please the matter accordingly. When it can be furnished, the report, Sharma.
My lord,
When?
my lord, is my lord. First week of September, my lord. My lord, on 10.
10th of September.
My lord.
10th. of
Hello, Lordship, same matter, Lordship.
Huh?
This is also 16, the same matter, Lordship.
16 also same.
Same. Lordship, both matter may be taken together, Lordship.
হেৰি বেলেগ নেকি মানে
But just order is different.
Petitioner different.
Just petitioner is.
Are different. Okay, same order. 16. Okay, we'll pass listing it on 10th of September.
Lordship, this matter may be taken together, Lordship. Otherwise,
It will come together at 10th of September.
Hello.
Oh. Oh. কালি হ'ব।
Met this here also. 528 application. Here basically the petitioner is challenging the criminal proceeding that is being currently undertaking before the London JMFC Jorhat in PRC case number 989 of 2019 arising out of Jorhat PS case number 2532 of 2018, which was registered under section 45 and read with section 34 of IPC. The very brief fact of the case is that this accused petitioner, he is not named in the FIR. Now, what has happened is how this FIR has transpired. On the particular day of the incident, that was on 17/10/2018, this particular informant, he was basically his halai machine, which is like cutting machine, was parked in the public road nearby to his house. And on that day, Swachh Bharat Abhijan was being undertaken under the directive of the government of India as well as the state government. And a lot of people came out and they were having this cleanliness drive being undertaken by the local dwellers residing in that place where this place of occurrence. Now, the main accused person, Vidyadhar Nath, he is actually the owner of the house where this accused petitioner was staying as a tenant during that period of time. He was on service related duty. He was there. He was working for a private company. Now, what has happened is that as far the FIR is concerned, the informant Ajit Das, he has said that this particular main accused Bidyadhar Nath had deliberately and intentionally caused damage by setting fire to his dhalai machine tire. And as a result of his intentional fire, his tire got burned, and then it resulted in damage, which is according to him, as per the section, more than 100 rupees in case of private property and 10 rupees in case of agricultural property. Now, after the FIR was lodged, then investigation was done. Now, very surprisingly, the investigation was done in a manner where they have seized, the police had gone to the place of occurrence and they had seized the half radial tire along with the machine. But we have not come across anything regarding any other accelerants or debris, which are very important if it is under section 435. Now they have seized it, and then they have gone and examined some of the witnesses, which may be like nearby dwellers who were there at that point of time. They have taken the test, he have recorded the statements of these witnesses, and on this basis of these witnesses, finally they have filed a charge sheet on 31/10/2018. And in the charge sheet, they have come across only 4 to 5 witnesses. In fact, the main informant name was also not there. But later on, now we have come to know, and we have annexed it, that the informant, his statement has been examined finally. Now, what has happened is that why we have approached this honorable court at this stage is that 2019, this case was, okay, we take into consideration the COVID, because COVID was also at that point of time. So there was some delay. Now, what has happened is that the charge frame, when the charge sheet was filed and later on when the charge was framed, it was done on 22/11/2019. The cognizance was taken in 22/11/2019 cognizance, and then charge was finally framed in 12/1/2023. Now from 12/1/2023, the evidence from the next day, evidence was there. So from 12/1/2023 till today, that is till the filing of this application, that is on 12/8/2025. Now the next date is on 22/9/2025 on next day. So till here, only 2 witnesses have been examined. And at the same time, 10 dates, no PW prosecution witnesses have turned up. Now, either it is the failure of the prosecution or either due to non-serving of the summons to the witnesses, this has caused, but there is an absolute delay. And it has caused prejudice to the interest of my career now. Because I'm a person now, I'm not staying there now because I was a tenant at that point of time. I have come down to Guwahati and I'm now working for this one, Asian Paint Company. And in Asian Paint companies, as Lordship may be knowing it, then in private companies, there are some particular incentives, reward schemes. Now, this person, due to having a criminal proceeding behind him, now he is not been eligible to apply for that particular incentives for going abroad because he is doing very good in his particular sector. But unfortunately, he is not able to now apply. His friends and all his colleagues are now going abroad and getting well trained. At the same time, as a reward scheme, they are also being given that incentive, but he is not being able to do so. So that is at this stage, that is why he has approached this honorable court, because of the fact that why there is a delay that is happening for such a long time. In fact, there is an order by the honorable JMFC that which directly says, we'll be going into that order, that no PWs have been turned up, and due to this, there is a halt. So when there is absolutely admitted by the court, now whose failure is this? And for that particular failure, now this particular accused petitioner is also, since he's a co-accused now, along with the main accused, that is the owner. Now the fact remains is that 435 is something which actually says that any mischief which is caused by fire or explosive substance amounting to 100 rupees or more than 10 rupees, that in case of agriculture, and more than 100 rupees in case of other property. Now, for that particular chemical report in case of fire or in case of explosive substance is very much essential. Now, as we go to the search sheet, we see that the relied document is only that material exhibit, which is the seizure list, 17/10/2018, where only 2 articles have been seized, and they have relied on that particular list. Now, if the prosecution has to establish a case based on the seizure list that they have seized these half-burned radial tire, but if they do not want to establish how this has happened, how the fire actually was caused, because on that particular day, lot many people were there. It could be done by natural act. It could be done by due to some other different circumstances could be there. But they have only directly, he has pinpointed that this particular accused, the owner, he along with this one person, having common intention. This person, this co-accused, who happens to be the accused petitioner in this case, he was a tenant at that time. So they are involved in this case. So at this stage, my lord, we only pray that to stay the proceedings and to call for the LCR. Because unnecessarily this has been completely dragged on. The witnesses, they have not turned up. Because why they will turn up? Because it was basically this entire case was taken up by the police on the, what you say, on the behest of the informant. Because he's maybe he might be having some grudge with this person. Nobody knows, with the main owner, because he's a neighbor. But just dragging this person now, being he was only involved with the Safai Abhijan, and that is also not at that time when this owner, he had initiated the Safai Abhijan. It was in the morning, and he accompanied it later in the morning, like around 9 a.m. So he had just gone there along with a lot of people, all were there. Now in the presence of those people, how can someone go and lit a fire or directly do something mischief of something which is already parked in a public place?
And these are the facts of the case.
Yes,
It's
yes.
appearing in it. Got it.
Kindly see, my lord, in subsequent dates, he also absent in the court.
Pardon? Orders.
Yes,
Okay.
in order sheet, my lord, he has annexed, my lord. In my lord, several occasions, my lord, he also absent.
No, he has been duly represented. Like he has filed petitions. Like he has already mentioned.
No, that is there.
Yes, yes.
That is there.
Now our fact is that the fact is that there is a delay. Now the honorable court has to take into stance whether that delay has been inordinate delay, or whether because of that delay will cause some inherent inherent, what you say, against the justice of the accused petitioner, or is it going to abuse the due process of law? So that will have to be like it will come only after we going through the record. So at this stage, kindly call for the LCR, because
And the notice to the restaurant.
yes, yes,
no?
absolutely. We have to file a notice. We have to serve a notice also to into the informant.
Your name is Vidya.
No, I am Dhrubajyoti Neo. I am already on bail now, and the main accused is also on bail. As we go,
Yes, in not exactly most of the, but you can say in most of the time he is absent.
Yes. yes.
look, the main reason is that now since he's working here, that is one of the reason. And so he has sent the representative on his part on all the occasions. He has never been absent by an
You are
applicant.
being represented or you are being absent with stay. That means you are not being, in any manner, you are not being, prejudiced by this order. Delay, obviously,
Yes,
delay is
yes,
there. I won't say.
absolutely. Yes, yes. Now the fact is that we need to go through
Because
the record.
case is pending since
We need to go
2019.
through the record by now, because
Otherwise, this is the case of 2019 pending is there. This
yes, and also
this
the
evidence is
materials which is
What about the other case? You want to, if for entire proceeding to be quashed
yes, we are challenging it
against you?
Yes, yes, because of the failure of the prosecution to establish a proper case, because of the fact that they have gone only with this particular fact that regarding
See,
that.
on the basis of evidence you are saying, or on the basis of the materials collected by the investigation?
No, we are going
officer,
to
on
the
what
charge
basis
sheet.
You are want to quash the matter.
No, basically we are with the going through the charge sheet. The number of witnesses which have been now, we will be annexing the testimonies also if required. Like if they have we have not given the evidence here. We have not annexed the evidence. We have only given the dates.
No. But the quashing, you have prayed for quashing.
Yes.
What basis you have prayed for quashing? Quashing only that you don't have your against you. There is no any materials. That is your main intention.
No. We are mainly with the delay of the proceedings taken. The delay so far that has happened. The second fact is that this particular case has been filed in a manner, and the investigation has been taken up in a manner which is against the prejudice of the co-accused, not against the main accused. We don't know, going against the co-accused because of the fact that the witnesses, how they have the 161 statements which have been recorded. So from the charge sheet, as we go to the charge sheet, if allowed, my lord.
No. I mean,
if it directly says that there are some witnesses and they have stayed.
Can it be? Is it a case for any state? I don't think.
No, man. Hello, kindly call for the scan copy of the record, my lord, and the notice to the restaurant number 2 at this stage.
Had Mr. W.R. Mehti, the learned counsel for the petition. And also had Mr. Now you are appearing as a additional BP state.
My lord, respond number 1.
State responsible one, B. Sharma. Huh? This is an application and so and so. For quashing of PRC case number 989 of 2019 arising out of Jorhat case number 2532 of 2018 under section 435 534 IPC, which is presently pending before the trial court, before the learned GMFC Jorhat. Issue notice to the respondents to register AD and as usual process. No formal notice is required to be served on state respond number 1. However, the copy of the petition may be served during the course of. Also call for the scanned copy of the TCR along with the case diary. Next, it is further submitted by Mr. Mehdi that the present accused petitioner is innocent and he is no way connected to the alleged offense. The investigation was perfunctory and without going by the perfunctory and without considering the involvement of the present petitioner, the case has been charged sheeted. At the relevant time of incident, he was only residing as a tenant, the prime accused, and otherwise he is not involved in the alleged offense. Further, Mr. Mehdi submitted that case is pending since 2019, but till date, the prosecution could not. How many witnesses examined?
2 of them have been examined till date.
But till date, only two prosecution witnesses could be examined by the prosecution, and thus there is an inordinate delay in the present case, which otherwise cause prejudice to the present petition. In view of this, he prayed for stay of the further proceeding in respect of the present petition. Next, brother. Hearing the submission made by learned counsel for both sides and considering all the aspects of the case, I do not find it efficacious to pass any order on stay at present. And the matter may be heard and decided finally on the appearance of the respondent number 2 as well as after receipt of the case report. List the matter accordingly after 3 weeks will do.
Yes, ma'am.
List accordingly after.
Oblige.
Take steps.
Yes, oblige.
More meeting as
But please, Your Lordship. This is an application under section 528 of BNSS, Lordship. Which one informant Mosomi Pal, Lordship, lost an FIR. This case number 62 of 25 under section 85, which is earlier 498, Your Lordship. This application is for quashing of FIR, Lordship.
Quashing of FIR.
FIR in page 12.
Charge sheet is filed, not
Not
yet
filed,
filed.
Lordship.
Now see at the time of filing of the, there may be prayer for quashing of the FIR, but we cannot stay the investigation. So we will definitely call for the case diary at present.
Lordship, and the informant already been died, Lordship.
Died?
Died, Lordship. After, actually, may parish the FIR, Lordship, in page number 12, Lordship.
12. Died means?
This is FIR, Lordship.
Last one. There is an allegation by ultimate, the last part.
Very cruel.
She said fire.
She had no other alternative but to take the such steps.
Yes, such steps, and thereafter, while getting treatment, she expired.
Then only she.
Yeah. So, that will not cover up this case,
Not at all.
Dying
Otherwise, also we will see to the stage of the investigation. Call for the case diary.
Yes, because he is on bail, my lord, he will not be
He is on
present.
bail. You are Mr.
Yes, Hussain, Lordship.
Heard Mr. S. Hussain. Your name is not here.
Not here, Lordship. On behalf of S. Yasmin Lordship.
S. Yasmin. Heard Mr. S. Hussain appearing on behalf of MSS Yasmin. And also heard Mr. MP to submit the learned additional BP appearing on. Hindi ki ba? This then so. For next part, call for the case diary.
Let's scan copy because if case diary comes.
Scan copy of the case diary. When it can be?
Yes, Sonapur PS 62.
Well, 16.
No, Sonapur PS 62 of the madam.
No, it will call for.
Yes, madam. After 2 weeks, my lord, any date, my lord.
After 2 weeks.
After 2 weeks.
After. Then it will be.
Obliged.
Calling for the case diary. Let us see.
Lordship.
May I please, my lord? I have item number 21. and I-
21.
21, my lord. I have some difficulties in the second half. So is it possible to adjourn the matter for today? 21.
21.
21, my lord. Because of some problem.
And the request for 21. After 1 week, we'll do.
We will.
List accordingly. As on a date to feedback. Okay.
Please, your lordship, in item number 35, the counsel for the respondent, she had to leave due to some emergency. She was here.
35.
35, your lord.
We have to hear because there are several the matters have been these are connected. Okay? These are all
Connected
connected
matters.
matters. So considering your submission, I don't know. Let the matter be reached. We'll see to it. Your counsel for the respondent is not present.
She was here. She had to leave for due to some emergency.
Who is she?
The CBI retainer counsel.
M. Kumari.
Yes, your lordship.
We had not only 35, in fact. In that case, 33, 34, 35, all are connected.
Yes, your lord.
3 matters are there.
3 matters.
কি কৰিব other side to ready আছে 33 34 30 at this time of calling next we have to call through. We have taken note of your submission. At 2 we'll call for the records.
Lord.
Otherwise, have you taken any concept of the other side?
No, your lordship.
No. They are not here, na? The appellant side is not here.
No, yes, your lordship, they're not here.
You could have make a contact with the appellant side because you have a prayer for adjournment.
Lordship.
So otherwise, this case was affixed for hearing any consecutive dates continuously. So, but if it is there, maybe your standing counsel may be in a position not to argue. But the question is that you could have informed the other side. But with they are not
But
here. na?
I'll inform them. I'll inform them, your lord.
You are MS?
And Chaudhary.
Well, pardon, MS, I'm sure. Is that it? In which item we are going to appear?
34.
34. So she had a prayer for adjournment stating that the standing counsel M. Kumari is not available.
Analogous method, lordship, 33 to 35.
Yes, all are analogous. So otherwise you are appearing on 34.
Yes, lordship.
But in 35 also
yes,
PM Chaudhary's name is there.
I will inform them, lordship.
You can inform. You are MS?
B. Goswami.
B. Goswami.
Oh.
On behalf of
D. Talukdar.
B. MS Chaudhary is MS Chaudhary appearing on behalf of standing counsel MS M. Kumari and stated that due to personal inconvenience, she had to leave court. It's not in a position to argue it. To which the counsel for the appellant speaker. B. Goswami appearing on behalf of Mr. T. Talukdar. There is no objection considering this submission. Also, prayer for adjournment is allowed. Late these matters, dates of the hearing. So also matters of fixed. Tuesday. 16th September is the Tuesday. We do not have, we can accommodate this way. This is a hearing day. Okay? 16th September. Okay, well, listing it on 16th September. All. You also inform the other two analogous matters.
May I please, Your Lordship?
Yes.
Lordship, here in this NIA case, being number 103/2019, additional chief judicial magistrate Borpeta issued NBW against me, Lordship. I could not appear on the day, Lordship. Order, Lordship, would find him page number 26.
26.
Yes, Lordship. On 17/8/2024, here it is written that complainant is present, accused is absent without step. Peruse the CR, which reveals that accused was defaulted on earlier occasion, issue NBW against accused. Here in this case, Lordship, petitioner is a nurse. He is presently serving as a nurse in health dispensary at Sonapur. So prior to that day, she could not appear before the court and inform her counsel. But on that particular day, her counsel did not take any step. Accordingly, NBW was issued, Lordship. Now, Lordship, I am ready to appear before the trial court, Lordship. But my appearance on this, I may be put behind the bar, so a direction may be issued so that I may be.
This order is of 2019. Thereafter, what had happened?
No, Lordship, it is 24. Case is pending.
No, you elect your page number
26.
20.
26.
This is okay. This is the order dated 17/8/2024.
24, Lordship.
Wherein your this.
Thereafter, Lordship, what happened? The learned counsel also did not inform of the case is pending, and accordingly, Lordship, these days has been elapsed, Lordship. Now, Lordship, as of now, as I have come to know that NBW has issued against me, I am ready to appear, Lordship. And I am a woman presently serving in the health department of Sonapur, Lordship. On that particular date also, Lordship, I could not avail loan.
Then you go speak for judgment only.
Judgment only, Lordship. So prior to that date, Lordship, I will appear. Till then, NBW may be kept in abeyance and I will appear before the learned trial court, Lordship.
And your next date is fixed on?
Next date is fixed on 25th of September, Lordship. So prior to that day, Lordship, I will definitely appear.
You're Mr. Handy,
Mr. K.K. Handy.
Mr. K. K. Handy, and Council for PNS challenging the inter order dated 17/21. Passed by Direct Court of Additional Chief Magistrate Court in NI case number 103/19 by issuing NBWA against the present petition. Next, it is submitted by Mr. Henry that the present petition was attending the court regularly, and in some occasion he was also represented by his and his counsel. But on 17/8/2024, he was not aware about the date fixed, and his counsel also did not inform about the fixed date, and for which he could not appear on 17/8/2020. And considering his default, NBW was issued against him. Thereafter, subsequent date also, the NBW were issued, as he was not being informed by his counsel. He was not aware about the date picked by the learned trial court below, and only came to know about the same. You have received the NBW? No, you came to know about the NBW.
I have come to know, Lordship.
And subsequently came to know that NBW was issued against him, and for which the present petition has been filed, paying for setting aside the order of 17/8, the subsequent orders passed by C. Next one, the subject order that the petitioner was regularly attending the court, and he is interested, and he is ready and willing to appear before the court and to contest the case according if he is provided with some protection so that he can retire. The annexures, especially the order sheets, filed along with the petition. I find that one opportunity may be given to the present petition appear at the trial court leader to contest the case. Next, this. The petitioner is hereby directed to appear to the learned court below with an appropriate application for bail, which may be considered in accordance with law. However, till his appearance, but till 15 days from the date of order, the NBWA issued against him will be stayed or suspended. So within 15 days, you appear before the
Gotcha.
trial court below. We have already suspended the NBWA for execution of the NBWA, so that you can appear and with the above observation. Petition stands disposed of with the same direction.
Gotcha.
Within 15 days, you appear.
Gotcha. Highly pleasant.
Yeah, His Lordship. Well, this is a maintenance, enhancement of maintenance against that, this being noticed in final space 14(9), Annexure D. This impugn order is passed by the additional session judge FTC, North Salmara. Well, 2,000 was the maintenance amount, and this respondent wife has filed a petition to enhance it to 50,000. 15,000 that was rejected the learned trial court, JMFC. Then she preferred petition criminal representation before this Honorable High Court. This Honorable High Court remanded back this matter to trial court, saying that
Rajnish versus Neha, on the guidelines of the Supreme Court decision, it should be assessed. So 4,000 is assessed from 2,000 to 4,000. Against that, the respondent wife has preferred the criminal revision for additional sessions as FTC. That was allowed. And from 2,000 to 14,000, it was. So this has been, it was agreed by 250% increment at the stroke. Because this circumstances says that he has two wives. First wife is staying in his house only. He take a rented house in elsewhere, and 1 bigha of land or with Betelnut, that is also she's enjoying. And her 3 children were along with this husband and husband, that is with second wife. So he has only 1 year left for his job, 59 years old. At this stage, his loan also and for construction cost also of the house. So from 4,000, 2,000 to 14,000. So that is not justified. That is why he's approached.
The order?
Order is page 49, Annexure D. Originally 2,000 to 14,000, my lord. January 20. Sixteen to 24 is the order by JMFC. As 4,000 is fixed. MR2 of 2008.
But till now, you're paying 4,000.
4,000, that is no problem. If something more, no problem. But 14,000 is a problem for him because this evidence and it is discussed here. It says that his wife is not staying in his house only. He has taken a rented house in elsewhere. So 2,000, she's adjusted since 2006. Now, at once to exceed 15,000. But burden is upon this petitioner, my lord, because whole family is burden. So she has no such burden because son and daughters also with him, they have given the evidence, page 31, that we are residing with our fathers, daughters, and they are conducting the courses in Sai, then all girls also, TDC second year, science. So all burdens are there. Medical expenditure is there. It is evident from the PW1 and PW2s and PWs, my. So there should be a balance, my lord. That is why I am not against the 4,000 is there, my lord. That can be paid. Not 14,000, my lord. That is fine. But notice may go. And 4,000, my lord, may be given to directed to pay, my lord, regularly.
Mr. M.G. Boroma. The learned counsel for the petition. Pending the order. Anybody? Submitted to Mr. No, issue not. It do not respond. To register it and the process. Also. For the scan. Submitted by Mr. Boroma that this petition done and maintenance case was instituted against wherein order of 2,000 rupees 2,000 wherein rupees 2,000 was awarded as maintenance allowance and thereafter the respondent again instituted a revision petition for enhancement of the maintenance allowance, wherein it is court that directed the learned trial court to consider the matter after assessing their income in view of the order of the court, in case of passed in case of Neha versus what was the Neha versus Neha and what was the case?
Neha and Rajnish versus Neha, my lord.
Rajnish versus Neha.
Rajneesh present.
Yeah, sir.
Thereafter, learned trial court below had assessed the income and burden of both the parties and according the enhanced maintenance amount was fixed at ₹4,000 against the said order. But the respondent again moved another petition for revision, praying for enhancement, the maintenance allowance, wherein the maintenance allowance before the Court of Learned Additional Session Judge FTC North Salmara, wherein by order dated 21/01/2025. The additional session done has enhanced the maintenance allowance from ₹2,000 to 14,000 per month. It further submitted that the enhancement was done in a very arbitrary manner, without considering the burden of the present petitioner, who is where the petitioner and also did not consider the fact that the children of the respondent are also staying with the petitioner. Accordingly, it submitted that the order 21/01/25 may be stayed. Other aspects of the case, let the petitioner is hereby directed to pay 50% of the awarded amount, that is 7,000 per month, till the disposal of the petition. States of clearly issue notice to the respondent to register for the scan of this year. Please the matter accordingly as on a date to fix by the ministry. You pay 7,000 for interest.
7,000. I think it should be 5 or 6. Obligation. 7,000.
My please, Lordship. Lordship, in item number 19, the order which was passed against the accused, she is a lady, but in the petition it is typed as he. The typographical error. I mean, item number 19, the accused is a lady, but in a petition it was misprinted as he.
Oh, he is not she. He.
Not it is she, not he.
He is she.
She, not he. Is a lady.
19 টপে লিখে নিন। কি ছিল না একটু সি হবে ওকে none appears on board for the petitioner. Release the matter after 2 weeks as on a date to fix by the registry.
May I please your lordship? Lordship, I'm appearing on behalf of Tishum lordship. Matter will kindly adjourn for the day lordship. Today some difficulties lordship.
At the request made by the Learned Counsel, matter is entry listed accordingly. After 2 weeks, it will be listed. Accordingly, after 2 weeks, as on a date to fix by the registry.
Obliged.
In this case, the petitioner, along with another accused persons, they were arrested and subsequently they were released on bail. The IO, after completion of investigation, submitted charge sheet. Trial started. Both the accused were appeared, but as this petitioner is concerned,
He appeared for his counsel filed a petition. With a step, he remained absent with steps. His advocate has taken a step. Then
He was
subsequently,
represented by his counsel.
yes, madam. The subsequently, an order was passed that he was directed to appear, but he has not appeared. And thereafter, a loss of kindness he pays, annexure 6 page 36. Order dated 35/2022. Accused orally he absent with petition, Spencer, adjournment. The accused allowed. And the accused answerable, he is the petitioner, my lord, is absent without any step by that date. Earlier he appeared through counsel. In the earlier dates, this accused was provided last chance to appear. Despite the same, the accused remained absent. In the meantime, the 3 witnesses are appeared after receiving summons. Concerning above, issue NBW against the accused answerable, and the case record against the said accused is split up. My lord. So then case was positioned against the only Warres Ali. Then accordingly, 7 witnesses has been examined, and after trial, my lord, that persons were acquitted. A loss of kindly see the page 51. And he was acquitted. Then thereafter, my lord, a split up file record has been prepared. Page 52, loss of kindly see. Present split up record is prepared for the accused Asrabul Islam, is the petitioner here. The said accused is absent, issue NBW. Then thereafter, the petitioner appeared and he was kept in jail. Your loss of kindly see page 53. His bail was rejected, he was in jail. Thereafter, he was ultimately released on bail. And he lost of kindly see the page 55 last order. By relaying the earlier evidence, that has been also taken into consideration. People also submitted that yes, on the basis of that, 7 persons who were examined, on the basis of their statement, his case also is to be decided. Then you will also kindly see, after passing that order, the matter was fixed for my statement under section 313 has also been recorded, page 56. By the order dated, the accused Asrabul Islam is present. The accused is examined under section so for the purpose of enabling the accused person to experience so that accused inclined to adduce any evidence fixed for argument. Then argument has concluded, page 57. Man. Accused is absent with this step. I have heard argument both sides fixed for judgment. The matter was fixed for judgment on so. But the accused was filed petition, filed present in Hazira, fixed for argument. Argument is not heard. Again, my matter was fixed for argument. Because in the meantime, his petitioner could not appear. He believed that since the judgment case was fixed for judgment, he will get acquittal. Because other accused person will get acquittal. So by mistake, he could not appear. Then the matter is again fixed for fresh argument. Argument is not heard, my lord. Then again, my lord.
No, just
Page 50.
On 14/6, an order was passed fixing the matter on 3/7/2023 for argument.
Arguments.
On that day, argument could not be heard because the adjournment was prayed.
Yes.
And then
my lord, page
7/2023, the
Yes.
matter was fixed for argument.
Yes. Both sides. I have heard the argument both sides.
When?
On that day.
24/7/23.
Yeah. 8/8/2023.
Argument is
Page
not heard.
57. Page,
Argument is not heard.
page 57, my lord.
57 is all right.
Page 57.
Ah.
Wonderful, good, this. 8/8/23, Bhandagola is there, my lord, page 58. 8/8/23, accused is absent with state. I have heard argument both sides. Argument complete on that date also,
Which day? Which day?
my lord.
Which day argument come?
8/8/2023.
Yes.
Argument concluded.
Ah.
But on
And
that,
it was fixed for.
it fixed for judgment.
22,
Is that
8,
what was it about?
2023.
Yes.
Yes.
But on day of judgment, he was not appeared.
Huh?
Day of judgment, he is to recur to appear, but he was not appeared.
Acha.
In the meantime, 45 days has been over. Then the matter was again fixed on, my lord.
Again.
Order page 59, 5/2/2024 order dated. Accused is absent without any steps till 12/22. Issue NBW against the accused persons. Fixed censure for appearance and argument. Again, my lord. Again, it was fixed for argument. Then the accused is absent and below my lord heard at the time issue NBW, my lord. Now let's look at see page 60. In the meantime, case was transferred, my lord, to the from the district judge Golpara. Now page 61, let's see. Page 61. Order dated 29/1/2025. Case is put up today. Date was fixed for declared holiday. No rebus. Fixed on 5/3/2025. On 5/3/2025, the accused is abstain without any steps. Issue WA issued against the accused person has not returned. Accordingly, issue fresh and against the accused persons and also notice to his bailer. Fixed 10/4/2025. On 10/4/2025, we will also kindly say page 62. Accused person absent, NBW against the accused person has returned with report that the accused person not found in his locality. Report also reveals that due to fear of arrest, the accused has absconded himself to facing the trial.
Yes, who is appearing this case? You are appearing.
So, well, I
All
See
fraud,
his conduct.
all fraud, my lord, his conduct is not good.
Not at all.
All fraud, my lord.
My
And
lord,
even after fixing the judgment, my lord, he is absent for consecutive 2 days.
he should be appear, but his counsel not instructed him, my lord. That on the day of judgment, he regretted. Now, ultimately, my lord, what happened? It was an impugned order, last order, my lord. Last order, my lord. Page 64. Last order. I have been declared as proclaimed offender. And case was filed. This is the order. But fact is this, if you also kindly see that statement of the EU, very not correct statement, my lord. You also kindly see page 64. His statement, my lord. The evidence of EU on his report reading the PNA is recorded during he deposed that he could not trace out the accused persons and hang the proclamation issued against the accused on a village road. Village road, my lord. My house is there, my family members is there, well, everything is there, my lord. I will never visit our house. And the petitioner, he was working in Haplung. He also no knowledge about that, my lord. I also made a statement that my family member is my house is there. Police never visited my house, my lord. So, my lord, I will appear. I will appear, my lord. And matter may be started from the state of argument. I will appear, my lord. I will
Sure,
regularly
I'll take
appear.
to submit. Okay, I have heard. I'll take to submit.
My lord, this is the last order, 64. Court hath made so many occasions.
Ultimately matter hard, fixed for judgment. Any condition, my lord, I will appear, my lord, on that.
Apparently, my lord, there is no wrong in this order, my lord.
Third study. Third study.
section আছে 45
So which order you have challenged now?
my lord
Your order, which order you have?
is a
challenged?
page 20 my lord page 64 my lord
That is the order.
this is the last order my lord.
Challenging the order.
It may be restored I will appear and
Challenging the order dated 17/7, whereby
as well as NBW my lord.
petitioner is declared as a proclaimed offender. Next item submitted. Yes, not come.
Episode is decided. 17 7 vote.
Wait, is the fact the case was charged against him along with one co-accused person. But and he was appearing before the court his against counsel. Thereafter, due to but thereafter he could not make any communication with his counsel, for which he remained unrepresented. And considering this aspect of the case, NBW was issued against him by, and the case is also split up against him by order dated 14/6/2020. And thereafter the case for the co-accused was proceeded. And finally, by order dated 9/2020, the co-accused was acquitted from the equity. Subsequently, on 14/6/2020, subsequently on
Master order I got the order master order
the case against the Rio and NBW was issued against the present petitioner. And he got arrested in connection with this case, in the strength of NBW. And after a considerable period, the accused was also allowed to go on bail by the learned assistant session judge called by. Thereafter, the case proceeded for and finally, the case was fixed for argument on 3/7/2023, and then again on
এটা নাই নাই কিছু সেখানে নাই এখানে কাটা নাই দেখছো
3/7/2023, and then again on 24/7/2023. Case was fixed for argument, and and subsequently on 8/8/2023, the argument was heard. This was fixed for judgment on 22/8/2023.
Hello,
You have not annexed the order of
8 2023 right?
Yes, 8. No, 22/8/2023 order.
22
8. 22/8.
I hand over 22
22/8 আছে নেকি? No, because judgment was fixed on 22/8/2023. Have you
Yes.
annexed this order?
Yes.
Where's your-
I pass 22 That two other slip. Is a
So what happened on 22/8? Do you have an explanation?
No, I'm not prepared.
You have not,
Not prepared.
but on 22.
That is a 45 days over.
Three, huh? It was a, but on 22/8/2023. Strike copy stuff. The record was put up on 24/8/2023. And thereafter, the case was again for judgment on judgment. But the, so what is your explanation? And when the case was,
My lord,
no, 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 no.
I mentioned.
No, no, no. When the case was fixed for judgment, you have not appeared.
Not
Why?
appeared.
Why? What is the case?
Because he was not available, my lord. But
He was not available.
no, but
Yeah.
he believed that
Oh.
since the case was fixed for judgment, so ultimately judgment will be delivered. I will get acquittal because on the same set of evidence, co-accused has already been acquitted, and no material has been found against in the evidence.
But
I can't
he
prove the
said he
evidence.
was fixed for judgment, but he did not appear before the learned trial could be.
And he was owing to Hablum.
Impression that as the co-accused had already got acquitted on the same
And he
set of
believed that.
evidence, he will also get an order of, and accordingly he went for his piece of work at before.
Hablum. He was working there from beginning. Paragraph 28.
He is absent.
29
The
had I
learned
mentioned.
trial court below again issued NBWA against him, and subsequently, once the examining the executing officer, the executing officer, the case of the present accused petitioner. No, and after examining the EO on 17/7/2025, the present petitioner was declared as an abscond. Next para. Mr. Ahmed Patel submitted that there is no willful
Paragraph
negligence
28 I mentioned.
negligence on the conduct part of the accused petitioner, and it was only for his wrong impression. He did not appear before the learned trial court below on the day of judgment. However, he is ready and willing to appear before the learned trial court below, and to face the trial and also to get the consequence of the judgment. Accordingly, he submitted he may be protected, and order of 17/7/2025 may be set aside and quashed. Next part. Mr. Sharma, the learned petition will be submitted. From the annexures filed along with the petition, especially the order sheets, it reveals prima facie that the accused petitioner was not only absconding at the time of his trial, but subsequently at the time of judgment also. He was absconding, finding no other alternative. Court had to issue proclamation against the petitioner. And after examining the executing officer, the case against present petitioner had to be filed, declaring him as an abscond. In such a situation, the petitioner is not at all entitled to any relief of interim protection. Hearing the submission made by learned counsel for both sides, I have also paid the evidence. Okay, sorry, I have also paid the case record and the annexures filed along with the petition. And it is seen that the petitioner is absconding since at the beginning of the trial, for which court had to split up his case from the other accused person. And in spite of releasing him on bail after his arrest on NBWA, the petitioner again absconded, and for which the learned trial court had to take the steps of issuing PNA against the present petition. Further, it reveals that on 17/7/25, examining the executive officer, the petitioner was declared as an abscond program offender, and case was filed against the petitioner. Thus, it is seen that even at the stage of judgment, the court had to take all endeavors to procure the attendance of the present petitioner, and finally had to declare him as an abscond. So considering the overall circumstances of this case, conduct of the petition, I do not find it at all a fit case to provide any interim protection to the present petition. However, the petitioner is at liberty appear before the learned trial court below with an appropriate application for bail, which may be considered in accordance with the above observation. Present criminal petition stands. This is not at all like Mohammed, it is a case for any interim protection. You
But
see,
I am not, I will appear, I will appear only, I will appear that the case may be heard from the stage of argument. I will appear, my lord. Within 10 days, I will appear.
Otherwise,
In the meantime, my
your-
lord, just,
your criminal petition stands disposed.
otherwise, my lord, so far as proclamation is concerned, you lost my kindly see, my house is there, my wife is there, my entire family is there. They say they are not found. They never visited my house, madam. Never visited.
So it is the duty of the court and police only to,
No,
to
no,
bring you.
no, at least they have the
But here
notice.
it is not your
No,
duty to
yeah,
appear.
correct, my lord. At least they should serve the notice to my family members, my lord.
Very okay. This matter is disposed.
I will
You, may,
appear.
you are at liberty to appear. You
Yes,
are at
my
liberty.
lord. And my case may be considered. My case may be considered.
As per law,
My lord.
in accordance with.
My lord.
You're going to use it.
May please, your lordship. The anticipatory bail application, lordship. Third time before your lordship, earlier twice rejected.
My lord,
Case that he was called for, it was lying for some time.
line for some time, my lord.
Case diary is available.
Available.
17/7.
77. Up to 17/7.
Earlier,
17/7.
no, up to 17th of July, it is updated.
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 Earlier,
And
lordship,
this is
what?
lying before this court.
My lord, it was initially called on 23rd/7, my lord. And
But
then
lordship-
from that day, city is here, my lord, because the order was to retain city.
Lordship, what happened? Twice the matter did not reach and the CD was available. So CD was retained. Once I prayed for adjournment on last day.
So I pray
So
for some,
it may be sufficient, lordship, 17/7.
almost it's more than 1 month back.
Because suppose if there is
But otherwise, my lord,
Any-
twice rejected. My
Twice
lord, the thing
rejected.
is that, my lord, what is the new ground? Because, my lord, earlier it was rejected
record people,
based on the materials only, it was rejected. The only thing is that the new ground, my lord, subsequent development. Otherwise,
so
materials are
that is one part.
Yes, my lord.
Subsequent development or any new ground. That
Yes,
is
ma'am.
one. And the second part is that suppose if there is any other progress that may help this.
Yes, because, my lord,
So that one.
I
needs
think
to be
there was
updated.
some undertaking that he will pay some amount of money at this and that, my lord. So, my lord, it will be better if it goes back and it is the updated one.
I think so, because
Yes,
that
ma'am.
may help him also.
That may help my case, lordship.
Yes, him also.
It should be.
Otherwise, new grant, I don't
Yes.
know if there is any.
Yes.
So two things are there, and one new grant and another one, there may be investigation
yes.
progress or what is the requirement that has to be.
Yes.
That is two grounds.
True,
So if it is lying before this court for a considerable period, and that too from 77, no entry is there.
Yes, ma'am.
Better for updation is
Yes,
required.
yes. Sure.
An updated case diary, Your Lordship.
Part Mr. and Hassan. Denied counsel for the petition. So part Mr. R.R. Kaushik. And the additional PP appearing on is submitted by Mr. Kaushik that the last entry in the case diary is on 17/7 and the case diary is lying in the court since 25/7. In view of Mr. Hassan as well as Mr. Kaushik submitted that the case diary record may be case diary may be set for updation and updated case diary may be. So in view of this, the case diary be calling for a updated one. How many days do you need?
My lord,
Kaushik?
on 17.
17.
On 17. 17 September.
7.
Lordship. Obliged. Lordship.
Here
You
also,
also
my lord,
received this scan copy, I think. Why scan copy here?
I don't know, my lord. Here CD is available, but the thing is that here also CD is up to date till 23rd April.
23rd April. But whether CD was lying here.
No, my lord.
This is your first
Yes, Lordship.
application or earlier rejected?
No, Lordship. This is first, Lordship. Perhaps, Lordship, this is listed before this honorable court as because Lordship was pleased to grant bail to some other co-equisters. So many bail
This
petitions were
is in
filed.
connection with some any NDPS letter or otherwise? Not NDPS.
No, not NDPS, Lordship.
This is BNS.
103 is there, Lordship. 302.
Well, here
And
up to date CD is required because
yeah, I think required, Lordship, as because, Lordship, some co-accused, they have been granted bail in the month of July only.
July.
July, Lordship. June, July.
and another aspect is that my lord, here one person died. Well, there are clashes between two groups, my lord. One person died and some other person got serious injury, my lord. Regarding the person who are injured, their statements are here, and they have specifically named this person accused. The thing is that, my lord, but the injury report of those persons who were previously injured, their reports are not here. Only the postmortem report of the person who died, this postmortem report is
But the
here.
person who claimed that they sustained injury.
Injury,
these are not.
their injury report is there. So the city may be up to that city.
And Lordship, in the up-to-date case diary, Lordship, the statements of this person who have been granted bail, those will be also there.
Yes,
Lordship.
yes.
Yeah, those
Yes,
statements.
yes, Lordship.
Mr. M. Ahmed, Lilanet also. Mr. Aran Kaushik, Lilanet also. Yeah, very on behalf of Mr. Right, submitted to Mr. Kaushik that last entry in the case that is of April 2021 and hence updated case diary may be followed. In that context, Mr. Ahmed also submitted that case diary may be updated and some of the co-accused persons were already granted bail and the statement of those co-accused may also be available in the updated case diary. Next, but in view of this, a updated case diary be called for. Issued yeah, very popular. Yes, when it can be 18, list on 18.
18. Highly obliged.
Okay. In Kurimulam, I have another 36. This matter is of 2022. To be very frank, I'm not in a position to hear the matter. In fact, I'm just I'm not.
Compromise করা হয়েছে।
It is
My lord,
compromise.
compromise is going on, but they are not paying, madam. Lordship may kindly see your lordship's order, madam. 24/1. No, they are not paying, madam. Still, madam, an amount of rupees 650,000 is to be paid to us.
Yes, my lord.
I mean,
Regularly,
yes,
they are defaulting, madam.
On last 2 dates, my lord, there is a fault on her part, my lord, that she has not able to pay due to some personal difficulties, my lord. But we will take instruction, and as per that, we will maybe next date may be given. We will instruct petitioner. my lord.
Otherwise, this is a case of revision under which cases for we have what nature cases.
Regarding out of the NI case, my lord.
Oh, it's an NI.
NI Act, my lord.
So
Post order is there.
NI generally we think that better option is for compromise.
Yes, my lord.
If both the parties will be benefited in that case.
Yes, my lord.
Money will be there, and then the interest may be waived, or maybe there may be a discussion.
Yes, my lord. As per compromise,
My amount was my lord 15 lakhs.
15
Out of that, my lord, still 6 lakhs 50,000 is yet to be paid.
that has been paid.
Yet to be paid.
Yet to be paid. Regularly, my lord, they takes time that they send the advocates. Already they are not paying, my lord. And court's order is also there, my lord. They have to pay in installment. Lordship's order, my 24-1. It's
24/1/25.
But your lordship's own order, my lord. My lord, and the last paragraph, the paragraph, and there is a remaining balance of rupees 7 lakhs, which will be paid by the petitioner installments basis. We are order from this honorable court. Even then, my,
Yes,
they are
my
not paying, my lord.
My lord, as per that, after that, 2 dates where we have no instruction, my lord. That's why we are seeking only 1 date, 1 more time, so that we will get the instruction, and as per that, we will ask our
So there
ask
was
the petitioner.
some order for some installments.
Yes, my lord.
So how many installments have you paid till now?
Till now, my lord, 6,20,000 has been paid, and 7 lakhs, around 7 lakhs is remaining, my lord.
My lord, installment has been paid on, my lord, 1, 2, 3, 4 installments, my lord.
4 installments, my lord.
4 installments have been paid.
Paid.
The amount paid is 26 lakhs.
6,20,000.
My 6 lakhs 50,000 is balance.
6 lakhs 20,000 is balance
Balance.
remaining.
6 lakhs 50,000, yes.
50,000.
6 lakh.
Lordship may give granted a small time, my lord. And I think they have to pay that as per the earlier order.
So what is your instruction? So now see,
regarding-
you are paying installment. That is actually not
Yes, my lord.
permissible, or it cannot be. But the
My-
question is just considering
My
the
lord-
aspects, most probably that was granted. But you should pay otherwise.
My lord, we will get some instruction, my lord. For that, after puja vacation, it may be listed.
For payment or for money, by that time you will pay something.
Yes, my lord.
If they pay, it's okay, madam. If they pay, make the payment, it's okay, madam. Otherwise, they will not pay, madam. There's the problem.
Now this will be very problematic for you also.
Yes, madam.
My lord.
In 2 constances. Aspect is there. One, you have not denied now, because once you started paying installments, that is you admitted.
Yes, ma'am.
So you don't have any alternative. So to remind you in that case. So even if some award is there, or even if the order is there, probability is there that may go against you. As because you have already admitted and started paying the installments.
Yes, ma'am.
So try to pay the amount,
Yes,
otherwise
ma'am.
there will be consequence, because if there is otherwise, because there are not only the principal amount,
My lord.
there will be some is as towards compensation this portion, or the other compensation amount will be there.
As on today, my lord, I have no instruction regarding how much, what is the last amount that has been paid, my lord. That's why 1 date may be given, my lord, after puja vacation, and then
You are Mr. You Mr. Talukdar?
SP does.
SP does.
For respondent number 2.
For respondent number,
2, madam.
state is here a formal party. State is a formal party.
Yes, madam.
No,
Yes, madam.
I don't know. And you are Mr.
BJ Talukdar on behalf of Mr. Ditul Das.
B. Talukdar.
BJ Talukdar
BJ
on,
Talukdar.
on behalf of Mr. Ditul Das.
Heard Mr. BJ Talukdar appearing on behalf of Mr. D. Das. And also heard Mr. SP Das appearing on behalf of the respondent number 2. This next para is submitted Mr. Das that in person to the order of this court, the some amount has been paid by the petitioner And but mm, uh, 6,50,000 is yet to be paid by the petitioner, which is it will be paid by the petitioner. In that context, Mr. Talukdar, the learned counsel for the petitioner, submitted that he has no proper instruction as on today as to what was the last amount of installment was paid by the petitioner. However, will take proper instruction, and the petitioner is ready and willing to pay the remaining amount of money. Remaining amount of the awarded amount, and accordingly he sought for some more time for the same. In view of this, case is adjourned with direction to the petitioner to pay some to pay the remaining amount in installment basis, and matter is listed. Matter may be listed immediately after whose application.
Not
and
kindly fix it.
whose application set for data. Whose application set for data.
Any date, ma'am.
Whose application. 13th reopening is on 13th. 14 is a hearing date, can be given on 14th.
Any day, ma'am.
14th then. Enabling the petitioner to pay the remaining amount on installment basis. Over. Okay, it will be fixed on.
Ma'am, August.
14. 14. 14. Aku tak boleh pun. Aku kini baru poin.
Yeah, please, Your Lordship. The Tengai Senior Counsel SR Chaudhary is in court number 1, madam. Can you pass about a matter for a time being?
No time being, I'm not in a position to hear the matter, right? Mr. The other side was the amicus was also there, na? As just for the amicus. Is there? Through the that. Not able to. No? Through the that. Time being কৰিব নোৱাৰো। কিহৰ কাৰণে?
Can you pass about for a day, my lord?
At the request made by the council. Matter is adjourned, list accordingly after 1 week, as on it. After 1 week, it will be listed.
Lord, I'm sorry, the matter was required to be, my lord, adjourned twice. I was on legs in court number 1, my lord. Now I stand free. My lord, in fact, I have some urgency. If your lordship desires to, my lord, hear the matter today, then, my lord, I can, my lord, submit. But your lordship can accommodate me, my lord. Then in that, my lord, case, I will ask for a fixed date, my lord, because there is some urgency in the matter. Because the trial court matter is fixed, my lord, I think on the first week of or second week of, my lord, September. So before
First
that.
week or second week?
Okay, second week, 15, my lord. So the matter can be fixed in the first week of September, my lord. Third, fourth, my lord, fifth, any day your lordship can fix it, man.
Fifth of September.
Deeply obvious.
Okay. Yes,
May I please, Your Lordship?
just a second.
My lord.
Here one I is also there and criminal, this is
Appeal.
jail appeal.
Yes, my lord. My lord, actually, this appeal was heard, previously heard in the court of Honorable Justice Vijay Saikia, my lord. Appellant side is already heard, and the respondent side is left out. Thereafter, the case was listed in another bench. Then also there is a direction to list the matter in appropriate bench. That means in the court of Vijay Saikia. Then the case is today is come, so I have informed the court to whether it may be heard today or press hearing may be taken today or in the other, as per earlier order, my lord, it may be listed
One
in
order
the
is
court.
there.
If there is a
On-
judicial order, then it should go there, my lord.
105/2025, one order is there, Justice Vijay Saikia order. Heard the MSBRS and the learned delegated constituents. This is the matter for Iman for hearing again. And on that day, Mr. P. Botapur, the learned additional PP for the state will make his submission.
Yes.
That means, otherwise it means that the matter was partner.
Partner.
So definitely it should be,
Yes, ma'am, it will be appropriate. to
because
say.
the order is specific, because heard at length.
Yes. Then,
You are at least pointed out.
and my learned friend has also stated that, my lord, subsequently there is another order to list this matter before appropriate bench.
Yes.
Meaning thereby to that particular bench. So that should be listed there only, my lord.
But the question is that it was listed on 5/8/2025 for before before Justice Saikia.
Yes, my lord.
But why it was an adjourned on that day?
My lord, that
Additional-
from the respondent side,
Respondent
time
side.
was taken, my lord.
Then again, we have to list it before the omni.
Appropriate bench.
Next para heard. Sorry, heard. Miss B.R.D. Sultan. Ilani Council. And also heard. Done. The appeal. Considering it's submitted by Learned Council for the petition, Learned Council for the appellant. It reveals that matter was, it reveals that the matter was asked to list before the appropriate bench by the order dated 29/05. In view of this, the registry hereby asked to list the matter before the appropriate bench. Want any fixed date here?
Yes, my lord. In that may be fixed. For hearing.
7/9/2025. 7/9? Is a hearing date, 7/9? Oh, sorry, 7/9 is a Sunday. Oh, both 7/9 would go then, but 8/9/9. 9/9, it's a.
9/9.
9/9.
Was nice.
Lordship, in this case, Lordship, I said file objection, Lordship, in IA.
You have already filed.
No, Lordship, I want to file, Lordship. Due to some technical error, Lordship.
One thing
could
is
not
just,
file.
I want to ask. Is there any, whether there is any prima facie case for this consideration of your suspension of sentence?
Yes, also.
Or you are going to submit on merit? If it is on merit, suppose, then better to hear the matter in fact. Entire matter can be heard. Otherwise, you have submitted your.
My prayer is that the IA may be taken up.
No, it
for
is
orders.
listed for hearing only.
Also, actually, KSI has already been received. LTR has been received, therefore the matter is fixed for hearing. But
Yes. we
this
can
IA
hear
is
the
not
matter.
disposed of yet, and there is some important. I'm going to press this IA also because what
Then
happened,
to
Lordship,
make
in
a
this case?
request before they raised it to make it to list the matter in the order column. Otherwise, it is listed on hearing column itself. So we are going to list
they are-
the matter in hearing. column.
Yes, they are going to
You are
file objection
going
also.
to submit the, I mean. You have already filed.
No,
Going
Lordship,
to file.
I have prepared, but not. Confused.
Also heard Mr. MS R.P. Bora, the learned legal counsel, opinion principle number 2, and Mr. R.R. Kaushik, the learned additional statement. It is submitted by MS Bora that the objection again in the I number I criminal 406 of 2025 already has already been prepared. But that could not be filed today, and accordingly she need some more time. File for this. In view of this, prayer allowed, is the matter according to what year?
17 September, Lordship. 17.
17 September is a what? It's a
Wednesday.
Wednesday, not, but don't keep it on Wednesday. Let it be on 18th September.
18.
It is, can it be taken up for orders because they are going
So
to
I'm
find
not
the
going to
objection?
pass, you can make a prayer before the rest. Because it is already on hearing call. You can hear the matter,
Because there is some,
because same exercise has to be done.
yes, Lordship.
That's right.
So-
God bless.
Those, this CBI matters, we fixed, I don't know, 17, 18 or,
That item 33, 34.
yes, yes.
They were taking time, I think.
Yes.
Fix.
16. 69 it has. There are we are supposed to take those matters consecutively from 26, 27, 28. Unfortunately, I was not there available on 26. It has been listed again on 27, but I'll take some rest and help some hot water and all. I'm not feeling well.
Yes, my land.
Somehow it's just managing.
And weather is today again is very bad outside.
Oh, that's okay.